Good morning, everyone. If you're in the room and you're going to testify, you expect to testify today, would you please make sure you sign in on the roster over here so we can record that in our minutes today? We're up and running? Very good. Well, welcome. Good morning for day 2 of Joint Judiciary for the 2025 interim. I hope you noticed that we have a number of topics on the agenda for today. That's going to require that we be careful with our time, and I encourage everyone as you testify to please be succinct and on topic so that we can move through this agenda in a timely manner. Committee, when it comes to your questioning and your commentary as well, brevity will be greatly appreciated if you want to leave before 5 o'clock today. All right. So with that, Mr. Co-Chairman, any comment?
No, just going to reiterate what you said. I think yesterday the committee, I know for a lot of you, it was your first interim committee meeting and the discussion was robust. The questions were great, and just continue to show respect to the public and ask that the public show that same respect to the committee. And I think we'll have a wonderful day.
All right. So our first, do we need to do roll today, second day? No, I don't think so. All right. So our first topic of the day is fentanyl and controlled substances. Mr. Fuller, we have a brief. Or Ms. Nord.
Mr. Chairman, members of the committee, Clarissa Nord with LSO. This morning, I'll provide a brief overview of how several Western states are addressing fentanyl-related offenses. And for your reference, this memo is included in your materials as Appendix 9-01. And Mr. Chairman, I wanted to note that this summary is not exhaustive, but it highlights some recent policy developments that may help inform the committee's study. So to provide a brief introduction, fentanyl is a synthetic opioid that's estimated to be 50 to 100 times more potent than other drugs, such as morphine and heroin. And since roughly 2011, illicit fentanyl use has resulted in an increase in overdose deaths, with growing implications for public safety and law enforcement. So starting off with Wyoming's penalties for offenses including the manufacturing, delivery, or possession with intent to deliver fentanyl. Those are felonies punishable by up to 10 years in prison, a $10,000 fine, or both. And possession of fentanyl in amounts exceeding statutory thresholds can result in up to 7 years in prison and a $15,000 fine. Wyoming also criminalizes child endangerment involving fentanyl, and this includes instances where a child is present during the manufacture or sale of fentanyl, and that offense carries penalties of up to 5 years in prison and a $5,000 fine. For trafficking offenses, there's been some recent legislative actions in Idaho, Montana, New Mexico, and Utah, and they've focused specifically on increasing penalties for fentanyl trafficking. In 2024, Idaho enacted a tiered mandatory minimum sentencing law for fentanyl trafficking, and I'll briefly review those tiers. So if someone has between 14 and less than, if someone has between 4 and less than 14 grams, they face at least 3 years in prison and a $10,000 fine. For 14 to 28 grams, the minimum is 5 years and a $15,000 fine. And then for anything over 28 grams, it's at least 10 years in prison and a $25,000 fine. Trafficking is punishable by up to life in prison and a $100,000 fine for the maximum penalty. And a second conviction results in a mandatory sentence that's twice the duration of the first. Under this law, sentences cannot be reduced or suspended or eligible for parole until the minimum term is served, and individuals who solicit others to traffic fentanyl are subject to the same penalties. In relation to this statute, Idaho also adopted a drug-induced homicide statute, and it makes it a felony to provide a controlled substance that results in death, which is punishable by up to life imprisonment and a $25,000 fine. And then in 2023, Montana introduced mandatory minimum sentences for distributing fentanyl. So if someone is convicted of distributing more than 100 pills or 10 grams of fentanyl, they face at least 2 years in prison, up to 40 years, and a fine of up to $50,000. The first 2 years of their sentences can't be reduced or suspended, and they can't apply for parole during that time. For most other drugs, the penalties are up to 20 years in prison, but fentanyl distribution carries stricter penalties. Then during this legislative session, New Mexico considered, but they did not enact 2 bills For time's sake, I won't review those bills for y'all today, but that information is included in your materials. Utah enacted a bill this year and it takes effect, or excuse me, it took effect May 7th. And the law classifies fentanyl trafficking involving 100 grams or more as a first-degree felony, and it's punishable by 5 years to life in prison. Courts are prohibited from reducing, suspending, or deferring sentences unless specific criteria are met. For possession offenses, many states continue to apply general controlled substance laws to fentanyl possession, and a few states have introduced or enacted fentanyl-specific possession laws. So for example, in 2022, Colorado passed the Fentanyl Accountability and Prevention Act, and this aimed to increase penalties for fentanyl-related crimes. And the law classifies offenses by the amount involved, with the most severe penalties reserved for quantities over 50 grams or cases resulting in death. Possession and distribution are categorized into levels of various drug felonies. They have enhanced charges if the fentanyl is highly concentrated, sourced from outside of the state, or linked to fatal overdoses. And then Hawaii this year, they introduced a bill with mandatory minimums for both fentanyl and meth possession. And those penalties range from 1 to 20 years, and it depends on the class of felony. And the bill also restricts probation eligibility for fentanyl-related charges. So with that, Mr. Chairman, I'm happy to answer any questions, but Western states are employing a variety of options to address fentanyl.
Committee, any questions for Ms. Nord
Mr. Co-Chairman.
and Mr. Co-Chairman?
Thank you, Mr. Co-Chairman. Ms. Nord, one of the ideas behind studying this topic is to see if our laws are strict enough when it comes to a fentanyl distribution to a minor. In your research, I don't see anything dealing with that in any of the other states. Or is there something, Mr. Fuller?
Yep. So Mr. Chairman, at your direction, in our correspondence before the meeting, did a little more digging. And Wyoming does have a law. This is Wyoming statute 35-7-1036. And in that section, so subsection A provides that it provides quite a bit, but relevant here, if a person distributes, among other controlled substances, fentanyl being a Schedule II substance, or any of the analogs that are scheduled under Schedule 1 to a person under age 18 who is at least 3 years younger than the person distributing, then the imprisonment is doubled. So you can, instead of going up to 10 years, that penalty is imprisonment up to 20 years. Then subsection B of that section provides separate penalties if there is a drug-related offense that's committed on a school bus or within the boundaries or 500 feet from any K-12 school property. And the penalties would be as follows: if it is an adult who is distributing on the school bus or in the school zone, it's minimum imprisonment for at least 2 years, and then an additional $1,000 fine in addition to the penalty. And then for possession within those areas, it's an additional $500 fine. If it is a minor who is distributing or possessing in that school zone or on the school bus, then it requires the completion of a drug education rehabilitation program, community service, and monthly drug testing for a year, depending on whether it's possession or distribution or delivery.
Mr. Co-Chairman, follow up?
Well, that answered my question. How, Mr. Co-Chairman, Mr. Fuller, when were those statutes enacted?
Yeah, Mr. Chairman, I'll have to, if you give me a few minutes and proceed on, I'll look that information up.
I'm just curious.
Representative Kelly.
Thank you, Mr. Chairman. Looking through this legislation, I see fentanyl is addressed specifically, but there are issues also with fentanyl analogs, more powerful derivatives like carfentanil, which is 100 times more potent. Do we have any information on how states have addressed the derivatives of fentanyl that are actually worse?
Ms. Nord.
Mr. Chairman, specifically looking at Colorado, they did address those analogs in their legislation, so I'd direct you to that particular bill.
And
Mr. Fuller.
Yep, and Mr. Chairman, Chairman Olson, as best I can tell, that section has been in effect since at least 1971.
Mr. Chairman.
Representative Singh.
Thank you, Mr. Chairman. Do we have, Mr. Fuller, do we have any information on how states that have been dealing with this problem in a more severe way, what the results of their policies have been, be it like New Jersey, Delaware, or like Oregon?
Ms. Norton, any outcomes?
So, Mr. Chairman, I didn't look at those specific states. If the committee would like additional information, I'd be happy to provide that. With respect to the laws that were referenced in this memo, as you can see, a lot of these laws were enacted within the last couple of years. So in terms of the impact, they're still assessing those results and gathering that data. Colorado, there was a study that specifically looked at trends in overdose deaths and whether those decreased. And they found that there was no reduction in overdose deaths associated with the law's enactment.
Further questions for LSO? All right, seeing none. Mr. Thompson. Director Jones. Good morning.
Mr. Chairman, if it's all right, I've asked our counterparts at DCI to come up and help with some of the more technical questions that I believe are going to be coming our way.
Very good.
Thank you, Mr. Chairman. My name is Alan Thompson. I'm the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. And since this topic has come before this committee, we've had some robust discussion across the state on kind of two fronts. What is best for Wyoming and its citizens in relation to the fentanyl related crimes that we're experiencing and investigating across the state, and also the increased danger, or at least a perception of increased danger to our law enforcement personnel that are working the streets and encountering fentanyl and derivatives and other drugs laced with fentanyl, and just the various impact of all of that. I would like to also mention that our agencies have been working with counties on opioid settlement funding streams that come directly to the county through the CPS, so that'd be the community prevention specialists, in an attempt to use those funds specific to overdose reduction efforts, whether that be from a law enforcement perspective or a community health perspective. And WASCOP has also been using opioid settlement funds to offset the impact and overdosed instances specifically to jails. We're in the process of administering a grant that would be used after jail staff are trained on the impacts of well, all drugs related, opioid related drugs, and the increased overdoses that we've seen over the last several years. One thing that statistics nationwide indicate is that individuals have the greatest risk of overdose right after incarceration and being released back into the public. They'll be subject to forced sobriety during that time that they're in, and then they will get out and usually seek the substance they were using beforehand. And there's a lot of data that would indicate that that's the most dangerous time for them to overdose or die from overdose time. So doing things on the jail level and monitoring them and ensuring that they're not bringing substances into the jail. All of those things are a focus of that grant to help improve the safety of inmates and those just released from jail. So there's kind of a twofold answer to the question of fentanyl laws in Wyoming. As I'd mentioned before, the belief that our members think it should have a harsher penalty on street level law enforcement, simply because it is a more dangerous substance to deal with and encounter. One suggestion would be looking at the the weight amounts that differentiate simple possession between felony level and misdemeanor level. And I'll get to that in just a second. And then also the, sentencing. Most times law enforcement, is involved in the elements of the crime and successful prosecution, but the sentencing is a legislative and a judicial branch function that, we usually don't have much input on. But there is some evidence, as you heard testimony earlier this morning, that other states are seeking harsher penalties based on the danger that fentanyl presents to the public in addition to law enforcement. And also, my partners up here will hopefully talk about this a little bit more, but the synthetic or analogs of fentanyl is a worry from a law enforcement perspective that we can make sure that we can successfully prosecute based on the existing language and statute. And I think that we're probably where we need to be in Wyoming, at least for right now. But I guess I would draw the committee's attention to Wyoming statute 31-7-1031, subsection C, which is generally the statute that the subsection C differentiates between that felony and misdemeanor weight amount possession. So, for instance, in Wyoming, if you have 4 grams of methamphetamine and it's yours for personal use, that fits the felony threshold because it's over 3 grams. If you have 2 grams of methamphetamine for personal use, that would be a misdemeanor charge. That doesn't take into account the possession with intent to deliver or selling 2 grams or, all those portions of it, just simple possession. And subsection D or E as in Edward of that section talks about a specific weight that doesn't conform with the rest of the statute. Generally, that statute differentiates between 3 grams or 0.3 of a gram, depending upon the type of substance, except for cocaine-based crack cocaine is 0.5 of a gram. So obviously the legislature in the past found that crack cocaine was a danger to the public and reduced that threshold from regular cocaine of being 3 grams down to 0.5 of a gram. So that is something to consider, that there is some evidence that Wyoming legislature has done that before. But we would also ask that if you're looking at changing any statute related to fentanyl, that we kind of clean up those weights that don't coincide with anything else. I mean, the difference between 0.5 of a gram and 0.3 of a gram is very minute. Maybe we could change that language to also conform with 0.3 of a gram. And then maybe consider for a controlled substance known as fentanyl, no more than 0.3 of a gram. There is some concern with muddying the language in the statute, because if we refer specifically to schedule of drugs, it kind of makes it cleaner. So there's been some discussion about a bill that we had in 2023 that cleaned up language in the overall drug statute that seemed pretty palatable to law enforcement, because existing statute talks about plant form and liquid form and powder or crystalline form, but just referring to schedules of drugs, and regardless of what form they're in, they fit into a schedule of drug. It kind of makes it easier to understand what weights we're dealing with and what substance we're dealing with, as opposed to, for example, THC infused soda in Wyoming technically meets the definition of a liquid, but it's historically been prosecuted as a plant-based because the weights are vastly different with the liquid form and the plant form. Mr. Chairman, I feel like I'm going kind of across the board here, so I apologize for leaving the fentanyl discussion, but I think I would ask the committee to consider, if we're taking a hard stance on fentanyl, that we understand the dangers that it poses to law enforcement working the road, and put the weight of that in line with some of those other more dangerous substances. And I would also add that if you're looking at like LSD, which is 0.3 of a gram, or liquid forms, that's 0.3 of a gram. The reason I believe that's in statute as 0.3 of a gram rather than 3 grams is because 0.3 of a gram is about what a loaded syringe is, and the loaded syringe is very dangerous to law enforcement on the street because there's not a whole lot of gloves that really protect from that poke, and then the substance inside there, and the double contamination from wherever that needle has been before and what the substance is in that syringe. I think we would argue that fentanyl is one of those dangerous substances that might warrant that 0.3 of a gram threshold difference. And I think that's all I have, Mr. Chairman. I would like to ask my partners up here to kind of explain a little bit more about the analogs or the synthetic versions of fentanyl, and any other questions that you might have about fentanyl trends, I guess, in Wyoming is something that's kind of been changing a little bit in the recent past.
Thank you. I do want to keep the testimony tight to fentanyl and fentanyl analogs. Okay. And we could be here forever, right? So let's, Director Jones, we'll come back to the committee after I'm thinking that some of your questions might be answered by their testimony. So with Director Jones.
Thank you, Mr. Chairman. I actually would prefer to turn this testimony over to our scientist here who can talk about analogs and things that I don't understand, if that's okay.
Very good.
Good morning, Chairman Washit. My name's Sarah Barrett. I'm with the Wyoming State Crime Laboratory. I oversee our drug chemistry unit. We are responsible for analysis of all controlled substances in the state of Wyoming. In terms of fentanyl analogs, we looked back from 2007. That's when our data really started. So we looked back in all the data we have. We have about 15 unique fentanyl or fentanyl-related compounds that we've identified. I think there's the potential to be hundreds of them. In our statute, we talk about fentanyl, and then we also specifically name certain fentanyl related compounds. But then in our rulemaking process, we have a rule that addresses fentanyl related substances more generally. So everything we've seen to date, I believe, falls into fentanyl related substances. And I don't believe that there are any issues with prosecution, although that's generally not something that we know about. We don't usually, as scientists, know the outcome of a case. So with that, I'm here to answer any other questions you have.
All right. Committee question, Representative Ling.
Thank you, Mr. Chairman. Thank you for coming today. My question is for WASCOP. You mentioned the schedule of drugs. Would that circumvent anything that is up and coming with, say, it's always the next best thing when it comes to addictions? And so would this schedule of drugs get ahead of the drug problem on the streets and being able to create legislation to combat it?
Mr. Thompson.
Thank you, Mr. Chairman. I think we're always in that process of trying to get ahead of. As the testimony we just heard, I think we're there with fentanyl right now until we know that we're not. So I guess we don't have any specific suggestions for schedule changes or updates at this point until case law would indicate otherwise.
Representative Kelly.
Thank you, Mr. Chairman. We talked about 0.3 of a gram being a threshold because that's the danger level for certain chemicals. Well, of course, I'm hung up on the analogs here because looking at carfentanil, 0.3 grams is enough to kill 10 to 15 people. So from a law enforcement perspective, what would you like to see in statute? What would best protect law enforcement officers regarding these substances that are clearly more lethal than just fentanyl?
Mr. Thompson.
Mr. Chairman, thank you. I don't know that changing that threshold to 0 and making it a felony, the evidence doesn't seem to indicate that would reduce or increase the safety for law enforcement. I think that what we're looking at is making sure that in our recommendation for 0.3 of a gram is just that it's in line with other statutes and it's consistent with the wording in the statute. When we start to get different types of wording, it becomes confusing and difficult to understand when you're investigating those crimes, which drug is which. So that consistency in statute is one thing. A lower amount that lower than what the existing statute describes, and then that misdemeanor versus felony conviction would likely put people that put law enforcement into those dangerous situations out of circulation, at least for a little while.
Mr. Thompson, related to that, is it true that fentanyl in a powder form is more threatening to the inadvertent inhalation of the substance by law enforcement than when it's in pill form? Would it be advantageous for the committee to consider differentiating penalty depending upon whether fentanyl or analogs are in a powder or a pill?
Mr. Chairman, that's been a big discussion recently in law enforcement, because several years ago when fentanyl came on scene, we had instances of inhalation, of transdermal poisoning, of various dangerous situations that our street law enforcement were in, to the point that many agencies that could afford to do so wouldn't even test suspected fentanyl on the street. They would take it to a controlled environment with additional protections like HVAC systems and things like that to even unpackage it. Some of the most recent conversations that we're having would indicate that it doesn't seem to be as dangerous as we thought it was a few years ago. As a non-scientist, I don't know where we're at with that right now, but I would like to see if somebody at this table might be able to answer that a little bit better.
Chairman Washit, I don't see, I cannot distinguish between powder and pill form in terms of danger. I think the pills potentially are just as dangerous. Usually they're illicitly pressed, so it's not a good firm pill. They crush very easily. They turn into powder very easily. And so I believe the danger is pretty equivalent, whether it's in powder or pill form, if that helps answer the question.
It did. Thank you. Senator Kolb.
Yeah, thank you, Mr. Chairman. So I probably have more of a chemistry question here. On the analyzing the lethality of said different compounds, analogs, whatever it may be, that seems to be part of the question, is just the appropriate amounts. Like what are we talking about for lethality? Do you have a scale of lethality for different analogs or whatever we're talking about on these different compounds that people are illicitly using? That's my broad general question, Mr. Chair.
Chairman Washit, Representative Kolb. I don't have that information available today. I do believe that DEA has said about 2 milligrams of fentanyl can be fatal. Carfentanil is obviously much more potent than that. And then all the other analogs are kind of on a scale, and that requires looking them up each time we come across them to see how potent they are. I'll be very clear, though, that potency isn't a part of my responsibility at the crime lab. We don't really look into that. We're simply testing the substance to determine if a controlled substance is present. So I don't have really great information on the lethality of something.
Representative Chestic.
Thank you, Mr. Chairman. Also for Ms. Barrett, kind of following up to Senator Kolb's question. Apparently there's the amount of the substance is, we have a conversation about what level should we set it at. My question is, in your lab, how sensitive is your equipment? How minute can you detect? And if we set it too low, is it going to be impossible for you to detect that?
Ms. Barrett.
Chairman Washit, Representative Chestic. We analyze a broad range of weights, as you can imagine, all the way down to residual amounts. So our balances typically weigh up to 1 milligram or down to 1 milligram. And we are able to make identifications on things that are even less than that.
Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. Mr. Thompson, this question is for you. I'm particularly concerned with distribution when it deals with minors. Our statute actually seems pretty aggressive. The maximum penalty you can have is 20 years. And under 35.71031A, if you distribute to a minor, it looks like that imprisonment could basically double. my question for you and your members is that sufficient enough when we're dealing with distribution to a person under 18? Or is there something, you've talked about the weight, I understand that. But when it comes specifically to minors, is there something more you think we could do with the statutes?
Mr. Thompson?
Thank you, Mr. Chairman. It's not something that we've had consistent ideas on or a widespread voice on. I would suspect that double penalty provision in there suffices for that type of circumstance that you're talking about and the age difference. So I guess, Mr. Chairman, I don't have an answer for that from our membership.
Fair enough. Representative Singh?
Thank you, Mr. Chairman. I have a couple of questions for Director Thompson. Thank you for being here with us today. So can you talk to us a little bit about the actual situations that you're finding on the ground? I'm concerned about, so if we were to reduce the limits or the thresholds to qualify for a misdemeanor or a felony for fentanyl, which I agree, I mean, everyone would agree that fentanyl is a objective bad on society. But can you tell us about the situations where you find it's cut with another substance? So someone may think that they're in possession of something like LSD or MDMA or anything else really, and it's cut. So how would this affect someone who unknowingly is in possession of a cut substance and then suddenly they're charged with multiple charges per state law?
Mr. Thompson?
Mr. Chairman, my understanding of state statute is that the carrier is part of the weight of the substance. So, if it tests positive for fentanyl, then that whole substance is fentanyl. So yes, it would put somebody in a position to have purchased what they believe to be MDMA and run into law enforcement and, that substance tests positive for fentanyl and then would be charged appropriate to the statutes based on the substance that's in there. And then there begins to be some prosecutorial discretion involved because it's my understanding the lab can test for multiple substances in one product. So it could test positive for A, B, and C, and how that is charged, and then how that is argued in court. Yes, that could put somebody in a position that previously that one pill was under 3 grams. Now that one pill is above 0.3 grams, and it changes it from a misdemeanor to a felony.
Follow up?
Thank you, Mr. Chairman. Director, can you talk to us a little bit about the actual street prices of these drugs and how available they are to the public?
Mr. Thompson?
Mr. Chairman, it's been a long time since I've worked for a living, but maybe somebody at this table could give me some support on that one.
Director?
Thank you, Mr. Chairman. Representative Singh, the prices really vary over time. And some of the things that come into play is the availability of the drug at the time. And that can be specific to a certain county, a certain city, or the state. For example, in Cody, where, it may be a little bit more difficult to get that substance, that the price of it up there may be more expensive than it is in Cheyenne, where availability is just across the border. So to provide a specific number on what it costs, that's a very difficult thing to do. Because somebody can drive from Cheyenne down to Denver and pick up 100 pills, and the cost of their trip is much less than it would be for somebody in Cody to drive to Denver to get that same 100 pills. So ultimately, at the end, the price goes up because it costs more to get it up there. We've seen prices $30 to $100 a pill, depending on availability in the area. But it fluctuates really weekly. So those numbers just are kind of a broad interpretation of generally what you're looking at if you're in that business, I guess.
Senator Cole?
Yeah, thank you, Mr. Chairman. I don't know who this is going to be directed towards, so in general, could you help me with understanding it, enhanced penalties for in the case where law enforcement has been exposed to a dangerous substance and has negative consequences, potentially death? Are there sentence enhancements in place that address this, and do you feel they're adequate if they are in place? Thank you, Mr. Chairman.
Mr. Thompson?
Yeah, Mr. Chairman, I'm not aware of an accidental exposure impact on law enforcement. There can be some instances where existing statute can be used to charge additional crimes to people involved in that, depending upon the circumstances. That is a discussion that kind of came late in my preparation for today, was a separate or enhanced penalty related to that, but it's not something that we've vetted as an organization. It's just one of the topics that came up kind of late in this discussion for us. I would say that would not be opposed to exploring those options for an officer safety standpoint.
Okay, we have about half an hour more on this topic on our agenda. Any concluding comments or questions? No? Okay. Concluding comments?
No, thank you, Mr. Chairman.
Appreciate that. Thank you. Others in the room wishing to testify in regards to fentanyl issues? Good morning. Welcome to Judiciary. Not today.
Not today. Thank you, Mr. Chairman. Dickie Shaner here on behalf of State Superintendent Degenfelder. Excuse me. Appreciate the opportunity to speak on this issue and really appreciate the effort and attention you all are putting into this issue of fentanyl. And particularly, I'm here today to talk about fentanyl and minors. We've already had a great discussion on that topic, so I won't rehash everything that's said other than the superintendent has talked to many of her counterparts across the country who are dealing with this issue as well, and really trying to engage legislative bodies to see what we can do, if there's anything that we can do in statute in terms of penalties to help with this crisis. Wyoming, we've seen a spike in incidents of fentanyl in the last 3 years. We've seen many fatalities, and whether this is the be all end all, we can't say that certainly, but it's something we need to be looking at in terms of the stricter penalties to try to prevent this from happening. The statute that was discussed by staff and that you all have been looking at, 35-7, 1036A and B, it does look at enhancements for contact with minors. It also discusses by school district property. And so some possible things this committee and ultimately the body could look at would be looking at that age gap issue. There's, an 18-year-old or 20-year-old could distribute, and there's a 3-year gap. So if you had an 18-year-old dealing to a 17-year-old at a high school, they would not get hit with that enhancement. So that's one sort of loophole. Looking at what it sounds like Montana and maybe some other states are looking at with mandatory minimums for any fentanyl-related offenses that involve minors. And other enhancements, either in this specific statute or elsewhere related to fentanyl. And then looking at that subsection B, where it talks about the 500 feet from school property, looking at enhancing those penalties that exist in there, and both for adults and minors who are both distinguished. So those are some potential solutions. I also submitted a memo that just adds to what your staff talked about with neighboring states and threw in some examples from what some other states around the country are looking at, all the topics that we've been discussing. Mr. Chairman, with that, just again want to reiterate, the superintendent really appreciates the attention you're paying to this issue.
So, Mr. Shaner, I think there's a couple of things. I do appreciate you being here today. I hope you enjoyed the drive up. Enhanced penalties only seem to matter if people are aware that they exist. There's no deterrent value in a penalty that catches somebody by surprise. So is the superintendent's office interested in partnering with other agencies of state government, perhaps, in terms of if we pass some enhancements in terms of helping us let the public know that there are more severe penalties for selling these drugs on school grounds or to children and those sorts of things?
Mr. Chairman, absolutely.
Mr. Vice Chairman.
Vice Chairman.
Co-chair.
Oh, man. Demoting me. What did I do wrong yesterday? All right, Mr. Co-chairman, my question is you honed in on the age gap in the statute. So would the superintendent's position be to address a different age gap or eliminate it entirely?
Yeah,
Mr.
thank you,
Shaner.
Mr. Chair, through you, Co-Chair Olson. I haven't gotten into that level of detail with her, so I wouldn't be able to speak specifically to that. But it does look like an area that should be examined by this committee in terms of the high school situation and having fentanyl.
Representative Lee.
Thank you, Mr. Chairman. Thank you for coming today, Mr. Shaner. My question is about the statistics of drugs within our school district. Does the Department of Education track those?
Mr. Shaner.
Yeah, thank you, Mr. Chairman, through you, Representative Line. Not as a regular sort of data point that we collect or anything of that nature, but we do participate in different committees and task forces throughout the state in partnership with Department of Health. And for example, preparing for this meeting, I reached out to DCI and looked at some of that data. So we have some of the fentanyl data now, and we participate in that, but it's not really a regular collection or something that we're doing on a sort of standard basis at the department.
Mr. Shaner, are you aware of any overdose deaths involving minors in Wyoming?
Thank you, Mr. Chairman. The only data I was able to find up to this point is from the Department of Health, pointing to about 53 fatalities with fentanyl relation in, I think it was 2022, and no ability to discern whether minors were involved or not at this point. I haven't been able to dig in deeper with them. They may have some of that data, but at this time, just the number itself.
Representative Filer.
Thanks, Mr. Chairman. Mr. Shaner, I don't know if you'd even have any type of data or an opinion on this, but if we was to change these statutes, make the penalties a lot more strict, do we see a path of maybe possibility of the drug deals going down, say in a high school with minors selling the drug in order to divert away from the actual problem with whoever's supplying that minor? So if they're, they'll recruit anybody they can to sell their drug. There's no doubt. I just wonder if there's anything that we could maybe add or talk about in the case of somebody being able to transfer that to the minor and then the minor selling it, because minor selling to a minor is totally different offenses.
Mr. Shaner, if you know.
Yeah, Mr. Chairman, through you, Representative Filer, it's a good question. And I think it could be looked at through the lens of that subsection B to start that we talked about, where it distinguishes between adult and minor, different penalties, talking about the school grounds, looking at what we could do there to deal with that issue.
Senator Coleman.
Well, thank you, Mr. Chairman. Morning. Mr.
Morning.
Shaner. A question, just, and I don't know if you know the answer, but I'll ask you. Posting of said penalties for possession of fentanyl or whatever it may be on school grounds. Are you aware of a blanket policy that exists currently with schools that make it mandatory that they post said penalties? Because I think that's a key factor here. You don't have any consequence until you get a consequence, right? If you don't know about it, then it doesn't deter anybody. So I think for me, talking about enhanced, throw them in jail for 100 years. Okay. But if I'd rather them know they'll have a severe penalty. And I just wonder, in a general sense, Are you aware of, or have you put out any information to the school districts requesting them that they post said penalties in a conspicuous place within our schools, within our state? Thank you, Mr. Chairman.
Mr. Shaner, the drug-free zone signage.
Yeah,
Penalty.
Mr. Chairman, through you, Senator Kolb, I'm not aware of a state policy that has that directive. However, as we engage in this discussion, we are happy to partner with school districts and the legislature on making people aware of the existing penalties, and if they're enhanced, making them aware of the enhanced penalties, because that's a great point.
Representative Singh.
Thank you, Mr. Chairman. Director, can you talk to us a little bit about how young people are actually ingesting this fentanyl? So I know, for example, young people get addicted to alcohol because there are strawberry flavored alcohols available and it's easy to ingest. Same thing with vape pens. There could be a strawberry flavored vape pen. So with nicotine and tobacco specifically. So how is it that kids are actually obtaining and ingesting these substances?
Mr. Shaner, if you know.
Yeah, Mr. Chairman, through you, Representative Singh, good question. In my research on this, there are several states that are specifically targeting that issue of appealing to a minor by manufacturing fentanyl to look like in a shape, color, or taste or design that would appeal to kids. So that suggests to me that there are individuals out there targeting kids with that, just like what happened with the marijuana laws when it became legalized. And I think what's particularly perilous about fentanyl is the lethality of the micro dosage and how it could be laced into just about anything and cause serious problems, particularly with minors who may have, less discernment and judgment and awareness of that.
Representative Singh, follow up.
Thank you, Mr. Chairman. So just to be clear, is it coming through like a vape, or is it like a fluid or a pill that kids are taking that you're seeing in Wyoming schools?
Mr. Shaner.
Yeah, Mr. Chairman, through you, Representative Singh, I can't speak to the delivery that we've seen in Wyoming with fentanyl.
Okay. Very good. Thank you for being here this
Yeah.
morning.
Thank you.
We have about 25 minutes left on our agenda for this topic. Is there anybody else in the room wishing to testify on fentanyl? Anybody on Zoom? All right, I'm going to close public comment. Committee, what's your pleasure? Representative Filer.
Thanks, Mr. Chairman. My pleasure would be I think that we should actually study these penalties. I think we should look at that whole section 31 when it comes to penalties, how we're going to address the concerns that Representative Kelly brought up and everybody else. I think this is a big issue, and it kind of hits home with me as I had a cousin out in Pennsylvania who died from fentanyl. It was a very small dosage, and it's getting more, I think, more rampant than we know here, even in our communities, even in Wyoming. So I think I would like, Mr. Chairman, as this committee starts studying this and maybe do a bill draft on the penalties and also encompass all the public education pieces and everything with this bill draft, Mr. Chairman.
Is there one of the states that you'd like to see the bill draft modeled after, or that we had the kind of open to just say, give us a bill draft on something?
That's true. That's true, Mr. Chairman. The most strict one would be the best. Whoever has the most strict laws, I mean, we have to deter this and start curbing it some way. And, so whether that would be the Colorado law or Utah law, I think I would like maybe staff to look at is who has the most strict laws when it comes to this, and then find that ground that actually works for Wyoming and start working that.
Representative Webb.
Thank you, Mr. Chairman. What I would like to see as far as the penalty goes is the penalties from some of the various states put in spreadsheet form so we can actually compare them, looking across rows and columns. That's what I would suggest for for ease of us to be able to follow those penalties.
So we got a motion for a bill draft. I was trying to see if the committee wants to help Representative Filer package that up a little tighter. Senator Cole?
Yeah, thank you, Mr. Chairman. If we're talking about a broad bill draft, I would certainly like to see that we include enhanced penalties for exposure to law enforcement and explore that also within the bill draft if it's appropriate, or maybe we need a separate bill draft, but I think we definitely need to address that. And in general, I think at this point, I'm pleased with the exploration of what the presented bill draft was stated as.
Mr. Co-Chairman.
Mr. Co-Chairman, so that's a really broad motion. It makes me very nervous. In one of, some of these states have, for example, mandatory minimums. I am adamantly opposed to mandatory minimums, and I think that takes away a lot of discretion of judges. But also, Wyoming has a rich history of avoiding mandatory minimums. It's not something that's not predominant in our criminal code. So in your bill draft, when you're looking at the strictest penalties, to me, that would be the maximum, increasing the maximum penalty. I just want to make sure maybe if that's the direction you want to go with it.
Mr. Chairman, Mr. Co-Chairman, I would agree with that too. I don't like taking power away from judges doing their job. And minimum, max or minimum sentencing and time. So I would like to make it where it is more strict, where they can go up to so many years and maybe doubling what we have on the books now or more. But I think it's something we need to look at. But yes, I wouldn't want to restrict the judges, Mr. Chairman.
Senator Craigle.
Mr. Chairman, just point of order. Number one, I don't even know if we have a second on the motion yet. So, but I will second it for the purposes of discussion. My only thought is maybe we hold off on the bill draft. I think it'd be helpful if we had a better idea of where we actually line up, because when we start talking about minors and distributions to minors, we're talking about a 40-year felony, because it's a double, right? So it goes from 20 to 40. Is that right, Mr. Fuller?
Yep, Mr. Chairman, Senator Craigle, for the fentanyl, because fentanyl is not a narcotic, at least as that term is defined, it would be 10 to 20. No, Mr. Chairman, that is so just the typical delivery of fentanyl is 10 years. That doubling, so if it is a minor, that would be the 20 years.
Mr. Chairman, so just to follow up on that, I mean, that's an easy fix. If that's something we want to do, if we want to single out fentanyl on the list that's already in 1031, I mean, that would be easily done. I just think it might be helpful to see where we line up. I think Representative Webb had a good idea of a spreadsheet, because unless we're just going to say fentanyl's a 20-year felony delivery, which is an easy fix, which could be the bill draft, but I'm not sure how that all lines up. I'd prefer to see where we actually line up at the next meeting and then have a bill draft done for our final meeting. But that's just a suggestion, because I don't know what the bill, to Chairman Olson's point, where we're actually going and what that looks like. And we might have a better idea looking at where all the other states line up as far as maximum penalties.
Right. I was just hoping we could coalesce some ideas here. Senator Hicks.
Yeah, Mr. Chairman, I would concur with the last comments that I said. I think we're premature. Not only would I like to look at what the other states do, comparable and analogs and all these issues that we've talked about today. I think we need to just go through the existing statutes right in front of us and see if it's just a matter of modifying those as the bill draft versus just draft a new bill. And so I would suggest we do what Representative Webb suggested, but I'd also like to actually work those statutes that 35-7-103 and 31 on the penalties subsection C, and look at that and see how what the discussion and what we want to do in a bill draft would actually fit into that. I think we need more information and a little more work on the subject.
Representative Kelly.
Thank you, Mr. Chairman. I agree with both senators just said. We're not ready to draft a bill. There's one aspect I'd like us to look at, and we look at the mathematics of what's a felony and what's a misdemeanor based on how dangerous that amount is. But there's a lot of gray areas. It testified here today. There are possibly hundreds of analogs out there. We don't know how powerful they are. So picking finite numbers for unknown substances may not be the best way to go. I'd like for us to look into a way maybe to draft legislation that is based on whether it's a felony or not, if it's a lethal amount of the substance or not, and that would cover whatever's invented between now and our next meeting.
Senator Crum.
Yes, Mr. Co-Chair, I agree with what was just said. Just a couple things that I'd like to look into if possible. One is this talk about lacing drugs. You know, you think you're buying something and you end up with fentanyl in it, and then a small dose of fentanyl because of the weight would throw you into a different category. I'd like to look at, you know, what's that really mean? You know, you thought you were doing something else and you get charged with something else. To look at that. And then to look at also is how do we, as Senator Cole brought up, how do we make sure people know what these penalties are and the enhancement to them? So is there a way to work with our public schools, private schools, and then the community colleges and the University of Wyoming on how to advertise that or put the penalties out in front of everybody so everybody understands what the penalty is? Thank you.
And with that, I'd like to go back to the bringer of the motion. Representative Filer, we're back to you. Would you like to amend your motion or withdraw your motion, or what do you want to do at this point?
Mr. Chairman, I think I'll withdraw it and we just maybe go with everybody else's suggestions as far as maybe getting some more information from LSO staff. There's this reading here with Senator Craigo on there could be some easy changes in the statutes that could actually help with all this. So I would just withdraw that motion and then maybe go with a motion of just getting all this information that we would need from LSO and look at the statute and see if we can just make changes on this on the next meeting for a bill draft.
So we're looking at a couple of statutes, 31.7.103 and 35.7.1036. Both have elements, I think, that are related to this discussion. Is that right, Mr. Fuller?
Yep. So Mr. Chairman, I think the direction that we're taking is we will prepare a spreadsheet of penalties for fentanyl possession and delivery, just in general for the states. Prepare a separate document that outlines those penalties if there are specific offenses relating to the distribution or possession of fentanyl by or to a minor. So focusing on that separately. And then, Mr. Chairman, we'll provide the full text of 35.7.1031 and 35.7.1036.
That sounds satisfactory to me, Senator Kolb.
Yeah, thank you, Mr. Co-Chair. Get that right. Also, information that evaluates the effectiveness of enhancing the penalties. Is there a relationship between putting somebody in prison for 40 years, over 20 years? Does that curb the activity that you're trying to control by enhancing the penalty? Does that make sense?
I think I looked at a textbook about that topic one time. Yeah, could be a lot of information.
Well, just in general, what's the general consensus on deterrent by enhanced penalties? And is there a point of diminishing returns? We throw everybody in jail for 100 years, or we go, okay, what really works is 20 years or 10 years the appropriate amount of time? If there is data, I guess I'd like to know about it as a member.
Mr. Fuller.
So Mr. Chairman, Senator Kolb, I mean, we can look into if that data exists. I don't think that's something that LSO ourselves could study and reach a determination, but we can see if there are studies out there that discuss this.
Representative Singh.
Thank you, Mr. Chairman. Just two quick comments. So if we were to talk about the most strict policies that exist when it comes to this policy, we could look at Saudi Arabia and Indonesia, but I don't necessarily think that's the route that this committee wants to go. But There are a wide range of philosophies when it comes to this. I am most concerned about distributors that would put forward a product that is cut with fentanyl and end up not only increasing the penalties that they face, but also increasing the likelihood of death through ingestion. And so I think that distinction needs to be made clear because of the different classes that we're dealing with when it comes to narcotics. Fentanyl is placed in a less dangerous class than substances like heroin or methamphetamine. And so how those two, well, how the different classes interact with each other, I'm very interested in seeing how that plays out. And so I'm glad we're pursuing this.
Good enough. And also, please make sure we have some language available about analogs and emerging substances. I think, if we can make sure, I think we talked about Colorado, some state had some analog language. If we could make sure we have that available to maybe insert.
Yep. So Mr. Chairman, and current statute, and this is 35-7, 10-14, 10-16, somewhere in there, Mr. Chairman, that describes that if a substance is listed, it includes its analogs, isomers, salts of isomers, and so forth. So that language exists in statute. And this kind of hints at Representative Lean's question from a while ago, but the way this would work is under state law, if there is a substance that the United States, the Drug Enforcement Agency, moves to a different schedule. So, Valero fentanyl, one of the newer, isomers of fentanyl, the United States moved that to Schedule 1. Under state law, we changed that accordingly and also included in Schedule 1. So in the rules of the Attorney General's office, a number of these fentanyl analogs are already, because they are scheduled under Schedule 1 in federal law, they're scheduled under Schedule 1 in state law as well.
Good. So are you clear on what we need for our next meeting?
Yep, Mr. Chairman, everything I said earlier, and then we will look for studies on penalty enhancements. And then I'll also include language, at least for the committee's reference on the analogs and isomers.
Very good. With that, we'll close the topic on fentanyl. I appreciate all the testimony today, and we have more work to do at our next meeting in Casper. Right? Which brings us to our next item, which
Mr.
is
Co-Chairman.
Mr. Co-Chairman.
I just wanted to take a moment to formally recognize that we have Senator Boner here joining us and Senator Steinmetz. And I think I saw Senator Steinmetz bring something in. Looks like it could be treats. And yes, Representative Lucas is here as well. So welcome all to Joint Judiciary.
Absolutely. Thank you for being here. So our next topic, obscenity and stalking. As a chair of the meeting, I want to take up the stalking issue first. I think it's a smaller discussion, hopefully, and maybe we can deal with it and then move into the obscenity topic. So, Senator Boner.
Well, thank you, Mr. Chairman, members of the committee. It's good to see you all here in Torrington. I think I can see Nebraska from here. I'm pretty sure if you look out the window, so it's good to be here. A nice spring day. Brian Boner, Senate District 2. I cover Converse and Eastern and Toronto County, and I appreciate the chairman especially taking up this topic. This was effectively a constituent issue that I became aware of just at the end of our session in March, and appreciate the committee's consideration here. So you'll hear testimony from some folks in Glen Rock that had to deal with a stalking situation, dealing with a minor child. And so you'll hear more about it. I don't want to, say something you're going to hear just soon, but I think it highlights the fact that we live online more than we ever have before. Our identities are online, and there's this change in technology has allowed folks who do want to stalk or harass anybody, but especially a minor, in ways that maybe wasn't possible even 10, 15 years ago. So You'll hear about the situation that led to this topic being an interim topic. Suffice to say, an adult was stalking a minor, and it, begged the question, should we have enhanced protections for minors as we do? I think you just heard with the topic you just discussed, especially considering I think there's an increased body of evidence that suggests that social media in particular, but the fact that we are so online and so connected can have a deleterious effect on the mental health of children in particular. And so you'll hear about that. I don't want to spend too much time respecting the committee's time, and you have far more compelling testimony that you're about to hear than I can give. But just I also don't want to offer a problem without offering a solution. So as you hear this testimony, after talking, not just to the victims in this case, but trying to talk to the defense attorney, talking to the county prosecutor, talking to the Glen Rock Police Chief. One thing that I think everybody's kind of agreed on is that you could, if you're talking about a bill draft, make a very simple one sentence bill that would have a big impact, that make this, if it's an adult is stalking a minor, make that a felony. There's currently 4 provisions in our stalking laws that make it a felony. This would be the 5th, and maybe there's more. Leave it up to the committee's discussion or your discretion and your expertise here. So think about that. I'm sure there's lots of other ways that the committee could take it, but that's one potential solution I'd offer right off the bat. But suffice to say, after digging into this, talking to the prosecutor, I think that was the question at Management Council: was the prosecutor competent in this case? And the question, and he absolutely was. I think they did a good job with the statutes that they have, but this situation has led to the question: maybe our statutes should be adjusted to account for changes in technology. So I'll keep it at that, Mr. Chairman. Leave it to some folks from Commerce County to tell you more about. Stand for any questions for the committee.
Questions for Senator Boner? Mr. Fuller, is there LSO comment on this subset of this topic?
So Mr. Chairman, just in terms of information, in the summary for this topic for the obscenity and stalking, pages 10 through 13 of that summary describe Wyoming's law on stalking, and then also includes a sampling of both federal law and other states that provide separate penalties or separate classes of offenses if it is an adult stalking a person under age 18, or in some states it's under 16.
Very good. You want to bring up your folks?
Yeah, sure. I'm sure they have it planned out. That'd be a good time to come up, and yeah.
Good morning. Thank you for coming to Torrington this morning and sharing the experiences that you've had so that we can hopefully improve our statutes. Who wants to go first?
Yes. So first of all, thank you so much for giving us this opportunity to be here. I am Kathy Holman. My daughter, Jillian Holman, is one of the victims. This is Brandy Sorensen. Her son, Preston Sorensen, was also a victim. And this is my husband, Dan Holman. As you can see, we have a packet of information for you. We will be referring to that at various points in our very short, I promise, testimony that we have for you today. We understand your time is valuable, and we tried to be succinct with what we say, and to each of us cover different things that were impactful and important to us. So we are available for questions. I thought it maybe would make sense, though, for us just to kind of read and present our information to you and then be available for whatever you need.
That'd be fine.
Jillian Holman will start us out.
Good morning, committee members. My name is Jillian Holman, and I am a junior at Glen Rock High School. I want to thank you for the time that you are giving me so that I can share my story, so that you can see why the Wyoming stalking laws must be changed. In November of 2023, several people in my school received anonymous text messages that were supposedly screenshots of me talking badly about them. Other texts followed, but my family didn't realize that this was part of a bigger picture until February 2024, when my parents received text messages from an anonymous number claiming to be a concerned parent. The messages described inappropriate and sexual behavior that I was supposedly engaging in with several males at my school. What at first seemed like a simple little text to get me in trouble led to a year of stalking and harassment. During this time, my parents warned me that this person could try to hurt me. I feared for my physical safety constantly, and at one point, because of the messages I was receiving, I thought I was going to get raped. My stalker was in a position of power as a chaperone on a school trip. She used those against me to further scare and intimidate me. My parents worried enough about my safety that I could no longer go out late at night or even go to the state fair because of the texts the people in the community were receiving from my stalker. In October of 2024, the police finally identified the stalker as a 41-year-old woman whose daughter I go to school with. In November of 2024, I was able to get a protection order in place that would last 3 years. In March of 2025, I went to a criminal sentencing hearing where I was given the chance to explain what I had been through and how it affected my relationship with my families, friends, coaches, teachers, and other members of the community. At the end of the trial, my stalker walked away with 2 years of unsupervised probation and a court-mandated counseling. This is what Wyoming's current stalking laws have done. They give room for a 40-year-old to stalk, torment, and harass a child and walk away with barely a slap on the wrist. When the criminal sentencing hearing was complete, I thought that my life could go back to normal. I soon found out that I was wrong. My stalker has continued to be present at important events that she previously used to target me. Because my stalker received just a misdemeanor and it is not a jail time, she gets to sit mere feet away from me as I cheer on my best friend at basketball games or while I participate in our town's tradition known as Grand March for Prom. I still constantly look over my shoulder and ask my friends to tell me if my stalker is around. Even just as recently as this past Sunday, I asked one of my friends if my stalker was present at graduation because I didn't want to enter the gym until I knew she wasn't there. I don't get to have fun and be a carefree teenager. I have to constantly look for my stalker because she has never had any real repercussions for her actions. Instead of enjoying my time in high school, I find myself constantly stressed and worried, wondering what an adult will do to me next. Instead of getting to have what most would consider a normal life, I find myself missing school and activities to be in court or meeting with the victim advocate's office almost weekly. I'm constantly trying to figure out how I can keep myself safe. It is not easy to continuously share what happened, but I have to at least try to make it better for future stalking victims in Wyoming. The laws have to change. I never want another child to feel as scared or as helpless as I have. As a victim and a minor, I should not have to be the one to continue to change my life when a perfectly competent adult was the one who committed the crime. An adult should not be able to stalk a minor and walk away with no real consequences. I am asking you as the people with the power to change the laws to help protect Wyoming's children. I know there will be other victims who will experience a similar situation to the one I was in. Please change the stalking laws to help protect future victims and to help bring them and their families justice.
Thank you. Ms. Sorensen.
I'm here on behalf of my son Preston. His experience reveals the terrifying reality of adult stalking of a minor and why our laws must reflect the seriousness of this crime by classifying it as a felony. From July 2023 to September of 2024, Preston was the target of persistent, escalating harassment by the mother of his ex-girlfriend when he was 15. What began as invasive texts and inappropriate involvement in their teenage relationship soon evolved into deeply disturbing behavior. His perpetrator sent messages suggesting intimate gifts between the teens, purchasing matching underwear, and even urging Preston to send an underwear selfie to her daughter. When I confronted the woman, she apologized, and I believed it was over. But what followed was worse, a calculated campaign of anonymous harassment. Over the next 8 months, Preston, my husband, and I received dozens of messages and a letter pretending to be classmates or concerned community members. The harassment included fake social media accounts, including one impersonating my son Preston, and texts that referenced using burner phones and spoofed numbers to avoid being caught. Throughout this period, still presenting herself as a trusted adult, she continued to pressure Preston, urging him to marry her daughter and emotionally manipulating him to stay in contact. We later learned the same adult woman was behind all of it. When we discovered this in October, we were stunned. This was deliberate and extended effort by an adult to psychologically manipulate and harass children. My son, a 6'5" champion wrestler who rarely feels anything, froze in fear that night upon hearing a woman's voice outside, believing she had come for him. He told me he had never been more afraid in his life. Being stalked is very traumatic, and there are multiple aggravating factors that I believe makes it even worse and more traumatic. Stalking committed by an adult against a minor is fundamentally more harmful than peer-to-peer stalking because of the deep power imbalance involved. Kids are taught to respect adults, so that made it very hard for my son to tell an adult to leave him alone or that she was being inappropriate. Not to mention the difficulty for him to confide in other adults or seek help. The potential for manipulation, coercion, and even grooming behaviors is also significantly higher with the perpetrator when they're an adult. Minor perpetrators often lack the same level of planning, sophistication, and sustained intent as adult stalkers, and their actions may be more impulsive and less complicated. The extended length of the stalking has devastating psychological effects on victims. The constant fear and uncertainty associated with being stalked erode a victim's fundamental sense of safety and security in their own life. This leads to chronic anxiety and a state of hypervigilance where the victim is constantly on edge, anticipating the next act of harassment. While we stayed quiet during the police investigation, once it became public, teachers and coaches shared they had noticed something was wrong. The emotional weight was clear. The anonymous nature and the use of technology to avoid detection heightened the level of anxiety, wondering who it was, how they knew what was happening, or what he was doing. It was considerably more difficult to investigate and apprehend the stalker, which prolonged the stress and worry that it would ever stop. The grooming nature of some of the harassment not only intensified the anxiety he experienced in the moment, but also contributed to long-lasting psychological effects. Grooming blurs the lines of what is appropriate behavior between an adult and a child, creating confusion, fear, and misplaced guilt at a critical time when he should have been learning how to build relationships healthily, understand his emotions, and safely navigate dating and other relationships. He was subjected to manipulation and boundary violations. This not only disrupted his ability to trust others, but also distorted his understanding of affection, attention, and power dynamics. The effects of grooming often linger well into adulthood, manifesting as difficulty with intimacy, identity confusion, self-blame, and chronic anxiety. I've been asked why there were no charges for the sexually charged messages that my son received. While I can't speak for our prosecutor who doesn't comment publicly about our case, I can tell you this law was looked at. And in my opinion, from talking to other prosecutors across the state, Wyoming statute 64303B2 that says a person is guilty of sexual exploitation of a child if, for any purpose, he knowingly causes, induces, entices, or coerces a child to engage in or be used for any explicit sexual conduct. While messages were sent talking about sexual things, they weren't asking him to engage in, nor could you prove that the picture would have been used for explicit sexual conduct. Prosecutors have the ethical obligation to only bring charges they believe they can prove beyond a reasonable doubt to 12 jurors, and they didn't feel this law fits the case. It's imperative that adult on minor stalking be classified as a felony crime. The unique confluence of the victim's inherent vulnerability as a minor, the perpetrator's position of power and authority as an adult, the increased potential for manipulation and more severe harm, and the cumulative and long-lasting trauma of protracted stalking necessitates felony-level penalties. Thank you.
Thank you so much.
My name is Kathy Holman, and my daughter Jillian Holman is a victim of stalking. I think that Jillian and Brandy did an excellent job sharing with you the basics of our family's story, as well as the emotional and mental impact the crime of stalking has had on our lives. For the sake of your time, we've included excerpts from each of our victim impact statements on the first few pages of your packet. When Officer Rachel of the Glen Rock Police Department called us with the news that Marcy Smith, an adult, was the person we had been referring to as the anonymous texter for the last year, I experienced a variety of emotions: rage, relief, and hope, because I felt that the end to the nightmare that my family had been experiencing was finally in sight. After I hung up the phone, I immediately Googled the stalking laws for Wyoming. Truthfully, I was filled with righteous anger. I wanted to see what punishment Marcy Smith would experience for the despicable things she had done to our families. When I saw that in Wyoming, stalking was only a misdemeanor with no stipulations if it was an adult stalking a child, I wept. I began conversing with those around me who were more knowledgeable about Wyoming's current laws and how they're created. I started asking myself if I could advocate for change in our laws so Wyoming's children could be protected. As we sat in court in March of this year and watched Judge Allen hold back tears as he called Marcy Smith evil and explained how what she had done had broken the trust of an entire town, two things happened. First, I felt something in me begin to heal that I did not realize had been broken. If you haven't been through our justice system as a victim, it will be hard for you to understand how discouraging and traumatic the experience is. Secondly, seeing that a judge was feeling as frustrated and helpless as we were because of how Wyoming's stalking laws are written gave me the courage to actively advocate for changes in our laws. It is too late for justice for our families, but I pray that we can make change for the future of Wyoming. While I know our story has had a lot of publicity, adult stalking children is something that has become a harsh reality in Wyoming. Sadly, our story is not rare. Nationally, 1 in 3 women and 1 in 6 men have been stalked at some point in their lives. Around 24% of female victims and 19% of male victims report being stalked as minors. I can hear your thoughts. That's the rest of the nation. Wyoming is different. I get you. In Converse County last year, there were 88 reported stalking cases. 5 of them were minors, and 100% of these cases, technology was used as part of the stalking. And I want you to keep in mind that 70% of stalking victims do not report. I'm not a lawyer, but thankfully I have access to many people willing to share their expertise with me and guide me along the process that has led me and the rest of us in front of you here today. One person shared a story eerily similar to ours, which occurred in Michigan. As I read the article, I saw that the stalker, a 42-year-old woman named Kendra Licari, was sentenced to 19 months to 5 years in prison for her crimes. I immediately looked up Michigan stalking laws and used them as the starting point for the changes I hope to see in Wyoming. If you turn your packet to the first page with red font at the top, you can see our proposed amendments to our stalking laws. We ask that an adult stalking a minor that has 3 or more years of age difference is a felony with up to a $10,000 fine and up to 10 years in prison. We believe the punishment should be proportionate to the amount of evidence collected and the period of time the victim was stalked and harassed. We also saw a need to add electronic methods for stalking and harassment into the definition, including social media, text, email, and electronic account impersonation of a known person. In Wyoming, the degree of damage the criminal does often separates a misdemeanor from a felony. In Wyoming, a misdemeanor theft involves stealing property or services worth less than $1,000. If the value of the stolen property or services is $1,000 or more, the crime is classified as a felony. Wyoming also has a 5 strikes rule, meaning that a 5th or subsequent conviction for any theft offense, regardless of the value of the property, will be charged as a felony. Based on this, I think it makes sense that an adult stalking a minor should be a felony. We are well aware of adults' power over children and the vulnerability that comes with a lack of age and experience. I believe our 5 strikes rule is comparable to the idea that with stalking, the punishment should be proportional to the amount of evidence collected. In our particular case, it was brought to our attention how outdated Wyoming's laws are regarding technology and crimes that are now aided by its use. If you continue to page through the packet, you'll see a few other changes we've seen a need for based on our particular case. The packet also includes a clearly laid out internet-related statute summary created by the Wyoming Cybersecurity Action Network. Laura Baker and her phenomenal team are ready, willing, and able to help Wyoming lawmakers with their vast knowledge and expertise. Their contact information is in the packet. The last few pages of the packet we provided for use contain the resources I found and eventually used to begin to process the process that has led me to where I am today, sitting in front of you and asking for your help protecting Wyoming's children. It is too late for us to receive justice for our family. Still, if all the hours I've spent in meetings, making phone calls, researching laws, and reaching out to fellow Wyomingites that see a need for change, if all that time ends up keeping just one mother from weeping when she Googles what Wyoming's stalking laws are, this was worth it. If the work we've done allows a prosecutor or a judge the ability to ensure that the punishment fits the crime, it was worth it. We cannot do this alone. We need your support, your expertise to implement these proposed changes in Wyoming stalking laws. Please help us.
Morning, Mr. Chairman, committee members. Thank you for the opportunity to speak here today. I'm Dan Holman, Jillian's father. 2 years ago, I would not have imagined a need for me to be here in this setting, asking you all for help. For the last 2 years, my daughter, my wife, and I have been fighting to make a wrong right. I don't need to hash over the details of the struggles my daughter and family have faced if you have heard them already. In the victim's impact statement I read before Judge Allen, I noted several times how I was unable to protect my daughter. I could not protect her from stalking. I could not protect her from harassment. I could not protect her from Marcy Smith's lies, slander, and malice. We closely monitored Jillian's phone and social media use, trying to keep whoever was stalking and harassing her at bay, while at the same time doing the best not to cut her off from her friends and community. Still, there was only so much we could do without completely isolating her. The lady who was at the root of this would text from multiple burner numbers or burner phone. We would have Jillian block them. When a message showed up on Instagram from an unknown account, Jillian would block them and try to move on. Kathy would get messages on Facebook and texts, emails, and I received text messages. Emails would come to us and our daughter's teachers and coaches. Harmful texts were sent to other youth in the community members by this lady pretending to be Jillian. Kathy and I struggled with how to handle this. How do we let our girl know what's going on without scaring her more? How do we keep her safe while still letting her be a kid and have the freedom she needs to develop into a young woman? Who can she trust? The isolation was one of the hardest things for her to deal with during this period. With the ongoing investigation, she couldn't share her feelings or concerns with her close friends. She wasn't able to defend herself or our family's character. She couldn't fall back on her close circle of support because we didn't know who the bad guy was. As all of you know, in a small town, there's plenty of talk. After Marcy was charged, we heard from several people that she wasn't concerned because it was, quote, just a misdemeanor. After she entered her plea to the misdemeanor charges and more details about the situation reached the public, we were swamped with support, with the exception of a few holdouts who just couldn't believe the lady they had known for 5 or 10 or 20 years could do something like this. One of those supporters or allies, whichever you'd like to call them, was texting people and telling them that it was, quote, just a misdemeanor. It's not like she killed anyone. Kind of makes you wonder where she heard it. Kathy can share those texts with you if you ever have an interest in seeing them, along with other harassment and slanderous things that Jillian faced. Speeding on its own is a misdemeanor. Speeding that causes an accident turns into reckless driving. I've had that ticket myself, so I'm familiar there. Speeding and reckless driving that causes an accident that harms someone or causes death can turn into a felony. If that speeding and reckless driving was an evasion of arrest, that becomes another felony. Add some booze to the situation, we got another felony. All of those small things together turn into felonies at different degrees based on intent and impact. I have seen firsthand the impact that this has had on my daughter. She has suffered emotional, psychological, and physical stresses at a time in her life when she should have been out being a kid. We had to put her in counseling. At the advice of law enforcement and the victim's advocacy, we had to come up with safety plans in the event that this turned physical. Marcy intended to do harm. period. Her actions were premeditated, malicious, and intentional. As an adult, she acted from a position of power to harm a child. This is not a case of a teen sending another teen a mean text. This is a prolonged attack on my daughter and on Preston Sorensen that lasted for over a year. Marcy Smith intentionally downloaded burner apps to disguise her identity. She bought a burner phone. She impersonated teachers and other members in our community for a year. For a year, she intently watched for impactful moments in my daughter's life that she could ruin. National FFA convention, state FFA convention, prom, regional wrestling, and various wrestling tournaments at the national level. Each county in Wyoming has its own county attorney, and those individuals have different appetites for a fight. We were fortunate enough to have a prosecutor who saw cause in this case, but didn't feel the statutes would allow him to prosecute the crime as a felony. On this journey, we've heard from others who think the case could have been tried as a felony. There shouldn't be this gray area in our laws, and this is where I'm asking for your help. We need to amend our current stalking laws so that there is clarity. Amend our laws so that the protection for our youth is clearly identified. Amend the current laws so that the prosecutors who have some teeth can have the tools they need to stop a predator like ourselves and the Sorensen's family have dealt with. Amend our laws to protect Wyoming kids. Adult on youth stalking should carry a more severe punishment than adult on adult stalking. Amending our current laws will help deter this from happening again. My daughter's as tough as they come, and I could plainly see the damage that came to her at the hands of an adult. Jillian and Preston's cases are not isolated events. As the public awareness about this has grown, multiple Wyoming families have reached out with similar circumstances. People have cheered us along, hoping to see positive change from this. The one thing that comes up repeatedly is the gratefulness that no one was hurt. Unfortunately, the consequences of these types of cases are often severe and permanent. Kids break under the pressure and the pain of stalking, harassment, and bullying, and do the unthinkable. Please do what you can to amend our laws and help deter this behavior in adults and hold the guilty accountable. Thank you for your time and consideration. Thank you. Kathy's open for questions, or any of us are as well, if you'd like them at this time, or
committee,
let's
any
follow up.
questions? Representative Bratton.
Thank you, Mr. Chairman. I just want to say thank you for your bravery. I'm so sorry that this thing happened to you and to your son, but you are you're so brave to come forward and make the change for to help make the change for other people. So and to you parents, the same. Thank you.
Thank you.
Representative Singh.
Thank you, Mr. Chairman, and Holman family. Thank you for being here today and for sharing your experience on behalf of the people of Wyoming. This is traumatic, and we're going to take action on this. So thank you for being here. Can you talk to us a little bit about your interactions with social media companies and the different apps that you were contacted by, how that complicated the court case?
The main struggle that we had, and obviously anyone fill in, was first of all, that burner app that was used to hide the numbers. There's absolutely nothing legally anyone can do to stop them from using it. It's untraceable. The other struggle that we had, and the break in the case, such as it were, again, I'm not a lawyer or anything, but I think that's the right term from CSI. The break in the case was when Marcy impersonated an educator and created a fake Gmail account. That is when finally the police officers were able to get a search warrant. It took 3 months for us to get the information back from Google. This is how people die. That was 3 months more of harassment. And then the only information, I mean, not only, it was great information, but the information that was received, and again, correct me if I'm wrong, was there's a special number with the phone, not the phone number, but the phone's number, the SIM card, that it was Samsung and that it was through AT&T. And also that the same phone that created that Gmail account also had the burner app on it. So then the police did another search warrant to Samsung and AT&T, which took an additional 1.5 months for them to get the information. That information then showed where and when the phone was purchased, the police officer went and pulled up the video, and that's how they were able to catch the culprit, because there was video of Marcy. So Google, I believe, needs to be held accountable for how long it takes them to get that information back. Samsung, AT&T as well. Again, if you look at it, this went on for another 4.5 months.
Ms. Press, Ms. Sorensen.
Thank you, Chairman and committee members. The only thing I would add to that is that also Facebook and Instagram accounts were created, some of which were kind of duplicated
Yeah, they were
from
fake.
anyways. And so really there wasn't anything that we could do as far as to Instagram or to Facebook. You can report them. I think everybody's had that experience of somebody got hacked or whatever, and there's not a whole lot you can do.
Further questions?
Mr. Chairman.
Senator Crum.
Yes, thank you guys for being here. I very appreciate it, and many others appreciate you being here too, so thank you. We heard suggestions about adult on youth, but then I heard during the testimony there was adult on adult. It sounds like stalking or harassment going on. I just would like your thoughts on that and any changes that may need to be done to the statutes related to that adult on adult piece that you mentioned.
Mr. Holman.
Part of the challenge with this case was there was a clear attack on our family and our family's character within the community, but I don't believe that fell within the stalking guideline. Most of the stalking was pointed at the kids or, in that general direction. I would say that what we faced was more slanderous impact.
Senator Hicks.
Yeah, Mr. Chairman, and one of the things when I look through the handout that you give me that's a little bit, I guess, just disconcerting for me, and I just was wondering if you wanted to opine, even under the misdemeanor statutes, it could have had up to a year jail time associated with this. And I don't know if that was part of the plea deal, but I just wondering if you'd like to opine, provide any commentary, disappointment with the reason for the suspension of the jail time, even under the misdemeanor.
Mr. Holman.
Part of the concern, we were hoping for jail time, clearly. We were hoping for jail time. The prosecutor came to us at that point. The defense attorney said that he was going to contest the validity of the search warrant, that he felt that the grounds were too broad. The prosecutor reached back out, talked with the Glen Rock Police Department, also talked with the Sheriff's Department there within Converse County, and they weren't sure whether he had any validity to the claim or not. The prosecutor suggested that we accept a plea agreement. He presented a plea agreement that had some short jail time tied to it. The defense attorney rejected it and said that his client would not accept the terms of the plea with the jail time. He wound up accepting the plea with no jail time because he felt that the most important part was to have a conviction in place to where if there was any continued interaction between Marcy and the kids, that we would have grounds to elevate to a felony from that point on. So he felt it was very important that we secure the conviction and not leave it at the hands of a jury.
Thank you. Senator Cole.
Can I add to that? Also part of the plea was I don't remember the statute of it, but it was kind of a plea that the judge could not go above and beyond, or he could not change it. He either had to accept it or go back. Our prosecutor also realized and weighed how it would be to have to put our kids on the stand and then be cross-examined by the defense attorney. We have been to multiple protection order hearings as they're fighting this, and having to just defend the fact that you were harassed and stalked is very traumatic and very hard. And so I think that he took that into consideration as well. I think if there had been felony enhancements, then he could have come with a bigger to begin with. And then as they agreed upon something, it could have, been a little less, but everybody could have been a little when you plea, that's what usually happens.
Thank you.
Senator Cole.
Yeah, thank you, Mr. Co-Chair. First, my condolences. I see you're a very strong young lady, and don't let evil people, hurt you. So it's tough, but I appreciate hearing this information. I do have a question though about why they couldn't issue a restraining order to keep said person away from you at a further distance like they do with anyone else, like domestic violence, let's say, where they can just basically say you can't be around that person. What happened there? Could you help me out with
Do you
that?
want to answer it or do you?
Thank you.
Jillian, she's proficient, sadly.
Ms. Palmer.
Yeah, when we first found out who our stalker was, we did get a temporary restraining order put in place until we could have a set court date to get a protection order. When we got our protection order put in place, we took into consideration that she is a mother and that she does have several young children that go to school with us. So we gave her the ability to still attend her children's events. With that, she is not listened to the protection order, so we are having to go back and change it. But the reason we did not do a distance or something like that was because we still wanted her to have the ability to participate in her children's lives and support them.
I just want to add that decision was made by Preston and Jillian in court when we were there for the protection hearing. We left it up to them what they felt comfortable with, and they had a discussion, and it was because they are great kids and amazing kids. It was important for them that her children not be more victims of the situation than they already were. And as Jillian pointed out, Marcy Smith has continued to push the gray area. So we were in court last week for protection order hearings, and we have another one on Thursday as well. Something that's frustrating for me is if this had been a felony, she'd be in jail. These kids could be back to their lives, not missing school, state track, to be in court.
Representative Lee.
Thank you, Mr. Chairman. Thank you, Holman and Sorensen families, for coming. You're raising the leaders of our next generation, and I appreciate that. Thank you for being involved parents. That makes all the difference that these children will be able to heal. I recognize that the grooming played a big section, particularly for Preston, and I would like to know, how do you feel about our current grooming laws, and may I propose one as we're moving forward?
Ms. Sorensen.
Thank you, Chairman. Senator or Representative Lean. I do not feel that grooming there are adequate grooming laws. I do believe that the grooming nature, and I didn't go into all of the grooming behaviors, but I do believe that there was a lot of grooming. The grooming laws that have been asked about is the sexual exploitation of a child. It does not fit grooming, which I believe are the behaviors that you just talk about it or ask if I am a MILF or, all of those things that are very disturbing and starting to head down a road and make things difficult. I do believe that a grooming law is necessary, and I would like to see something like that to be able to stop something or do something before. Unfortunately, this person has also been seen putting magnets on teenage boys' trucks that reference porn and stuff. And I also think how nice would it have been if she had been charged with something that she could be on a registry. Right now, our protection order says that she cannot volunteer at a school. She could move somewhere else and volunteer at a school. And that is very distressing to me as a mother.
Thank you. Representative Webb.
Thank you, Mr. Chairman, Mr. and Mrs. Holman, Mrs. Sorensen, Jillian. I'm sorry. We have a problem in Wyoming. You've made it clear. We have the responsibility to correct it.
Thank you again, all of you. Very powerful testimony and a horrific experience. And we look forward to seeing what we can do to make it better for the future.
We appreciate everybody's support. Yeah, feel free to reach out at any time to any of us if there's questions.
Thank you.
Thank you.
Ms. Chambers, you're on the agenda. Were you going to speak on this topic?
Chairman Kara Chambers, Division of Victim Services, Wyoming Attorney General's Office. I don't know that I have a whole lot to add. I think you heard some very powerful testimony, accurate testimony. I could answer any questions you had about the current status of our stalking laws. I can offer that. In my nearly 14 years in this position, we have approached this body on multiple occasions to enhance our stalking legislation because it is ever evolving, especially with the social media and electronic means. In fact, we've made an amendment as recently as 2 years ago to add GPS tracking to the stalking statutes. Again, just open for any questions. I did have a thought that Representative Lean's House Bill 189 would have criminalized this behavior had it been successful this past session. I assume that's what you're teeing up, so I'll let you speak to that. But stalking is one of the most nefarious crimes I've have to deal with, honestly. It does so much harm long-term to the victims and are some of the most indicators of future violence. Stalking of adult women is the leading indicator of future femicide. I mean, I could go on and on. I think the families have done a very good job of explaining the impact that this has had on their family. And I'm just here for any questions that you may have on our laws and procedure and policy.
Ms. Chambers, are victims of stalking eligible for compensation?
Chairman Washington, yes, they are.
Questions from Ms. Chambers? Representative Lean?
Thank you, Mr. Chairman. Thank you for coming, Ms. Chambers. With the expansion of a grooming law that we were able to get it through, do you anticipate that your office has the workload to handle that?
Ms. Chambers?
Chairman Washington, Representative, yes, I do. One thing I wanted to add about stalking and compensation, one additional expansion of eligibility for compensation is that we discussed very briefly yesterday that the first do not pass go is it must be reported to law enforcement. In the case of protection orders, if we have a valid protection order, whether it be for domestic violence, stalking, or sexual assault, that is also an inroad to compensation. So,
Mr. Co-Chairman.
Yes, thank you, Mr. Co-Chairman. I'm not sure if you can answer this because you may not know what other states do, but it seems to me like there are several changes we can make. The most obvious one is to amend the felony statute so that if it is a minor, it's an aggravated circumstance and becomes a felony. My question is, do you have any knowledge of other states that have such a law?
Ms. Chambers?
Chairman Washington, Co-Chairman Olson, mostly from the LSO update. So I'm hoping that they will get an opportunity to give you their research. But yes, I looked at Nevada, Arkansas, Minnesota, Vermont, Connecticut, and Missouri. I was not aware of Michigan's, but I will look at that. It would be a fairly simple lift to just add that as the fifth element that would enhance stalking to a felony.
Is that what those states do, or do they just enhance the misdemeanor penalty?
It looks like there's a couple different approaches, but it would make it a felony level punishment. Yes, it would make it felony. So Nevada, for example, if the victim's under the age of 16, the defendant's at least 5 years older, et cetera. I think the closest age I saw was Connecticut, where the victim is under 16, the defendant is at least 22. I'll defer to Mr. Fuller and his research, but
Mr. Fuller, you want to chime in?
Yep. So Mr. Chairman Olson, it depends on the state. Some states, particularly, for example, those states that have gradations of felonies, the stalking of a minor is a higher degree offense. Some states provide separate penalties or an enhanced penalty rather than a separate offense. Other states, a similar approach to, I think, is what's being discussed here, where there's a carve out if it is, the victim's a minor under a certain age, then that would trigger a felony offense.
Mr. Fuller, do any of the states have a duration element where if the stalking behavior continues for a significant period of time that the penalties change?
Yeah, Mr. Chairman, I'd be unable to answer that question. I didn't look into that particular question.
Anything further from Ms. Chambers? Yeah. Mr. Co-Chairman?
This is actually for Mr. Fuller. Just looking at the handout that was provided to us by the family, there is a section that talks about punishment should be proportionate to the amount of evidence collected. And then the period of time that the victim was stalked, that was the co-chairman's question. Are you familiar with any of those state laws that weight the penalty based on the evidence that is presented?
Yeah, Mr. Chairman, Chairman Olson, I'm not immediately aware of whether other states do that.
Ms. Chambers?
Chairman Washut, Co-Chairman Olson, I would be leery of how to codify that approach. I would argue that a dozen roses from a violent perpetrator who is now stalking a victim is as egregious as it's hard. I would caution you against what makes it worse. I think the act in and of itself, and it's how it's perceived by the victim, might seem benign to others, but can be truly, truly harmful to another. And I think I would caution against a slippery slope of trying to, well, this is worse than that approach.
Mr. Co-Chairman?
Mr. Co-Chairman, so to back up,
Mhm.
if we, based on your experience, is there an age level that we should set? Is it enough to say that it's a felony when it involves a minor, period? You mentioned earlier that some of these states have age thresholds. What in your experience would be an appropriate threshold?
Ms. Chambers?
Chairman Washut, Co-Chairman Olson, obviously that's a policy decision for the body, but I think you would want to be cognizant of how we make distinctions in other laws, whether it's sex offense, where we look at the age between the victim and the perpetrator. This is something that we actually got quite in the weeds with harmful communications about when we set the age of a minor, how much older does that defendant have to be to put it into that enhanced category? We run into the situation where, you know, we have a definition of a minor being someone under the age of 18. So if the offender's the 19-year-old ex-boyfriend, you know, what are we doing with that? So I would just caution the body to make sure that they're thoughtful about these distinctions of if we're elevating this to a felony, but I do think it's appropriate. Other states have done it. And I can see the additional harm you have in a situation such as this, where you have an adult who's stalking and harassing a minor. I will let you know that I've tried to do very quick research on this, and it's hard. We don't always necessarily track very well. While we might have the age of a victim and the age of the defendant, we don't always track the relationship between the parties. I don't know if that changes the situation. I will note that in Wyoming law, a second offense within 5 years is a felony. I think you heard the family talk about that. I think that was why it was so important to get this initial conviction. So we do, and the one thing that makes stalking so tricky is by definition, it has to be more than one event. And so you have these repeated offenses. And I do think you have situations. I'm working with a victim right now who we're 10, 15 years into this stalking, and the person's in another country. And it's so difficult to navigate and to pinpoint, all right, when are we, you know, when does it stop? When does it, you know, how do we quantify this? And are we
Ms.
just looking
Chambers?
at a charge every single time?
Ms. Chambers, the witnesses made reference to sex offender registry.
Mhm.
Do our statutes presently allow for inclusion of an offender under these types of circumstances as a sex offender, or will that take separate action on by the committee?
Chairman Washut, I don't believe stalking is a registrable offense on its own. And I'm looking at Brian because I know he's researching.
Representative Lean?
Mr. Chairman, I'm not sure about stalking, but in House Bill 189 from the last session, we did include the grooming portion to be registered as a sex offender.
Because there was a second.
Mr. Fuller?
Yeah, Mr. Chairman, it doesn't appear
didn't,
that
yeah.
statutes in the list.
So that would require an addition.
All right. Thank you, Ms. Chambers. Anyone else in the room wishing to testify on this topic? Is there anyone on Zoom wishing to testify on this topic? No. We're going to close public testimony committee. What's your pleasure? Senator Crago.
Mr. Chairman, I guess I'd kind of like us to keep this simple, but solve the problem. And so my preference would be to have a bill draft prepared. And I think Senator Boner mentioned this early on, that we can do this simply. Keep it clean. I think it increases the chances of us getting it through the entire process. So my proposal would be to have a bill draft prepared, amending 62506E, which is the felony stalking provision, and just adding, creating another subset there, a fifth element or a fifth crime actually for minors with a 3-year age gap, which is what the family has requested. And I think that's perfectly acceptable. So that would be my motion, Mr. Chairman.
And second by Senator Kolb.
Just to clarify, Mr. Co-Chairman,
Mr. Co-Chairman.
Senator Craigo, yours, and you said the 3-year gap, but specifically that the offender is an adult and there's at least 3 years between the.
Yes.
Okay.
Yep.
Discussion on the amendment or on the motion? Seeing none, all in favor of the bill draft proposal, say aye.
Aye.
Those opposed, no. Further committee action. Representative Lean.
Thank you, Mr. Chairman. I move that a bill draft be done for grooming. It be modeled after Montana's House Bill 92 with the penalty to include the sex offender registry upon conviction.
Is there a second?
Sure.
Second by Representative Singh.
Mr. Co-Chairman.
Discussion, Senator.
Mr. Co-Chairman, Representative Lean, how does the Montana law differ from the bill that you proposed in session? Or is that what you're proposing?
Representative Lean.
Mr. Chairman and Mr. Co-Chairman, is significantly shorter and more concise. I did just email it to the entire committee so that you can open it and see it on your laptops.
Further discussion on the motion? Take a minute if anybody wants to look that up. Your emails. Senator Hicks.
Yeah, Mr. Chairman, at this early in the process with the committee time that we have left, I don't know that there's any harm as to having another bill draft to look at as a comparison. I guess I'd be comfortable having a bill drafted to look at. So we've got two to discuss, and there may be parts of both that we like, but I certainly would be supportive of looking at another version.
Further discussion on the motion? Seeing none. All those in favor of the motion to have a bill draft on grooming based on the Montana language, say aye.
Aye.
Those opposed, no. You clear on that, Mr. Fuller?
Mr. Chairman, if Representative Lean could forward, that would be great as well. Thank you.
Mr. Chairman,
Senator.
just a quick clarification maybe for Representative Lean. So I pulled up the link. It's a very lengthy bill. I mean, the portion, and maybe we're just talking about the grooming portion of the bill. I mean, there's prostitution amendments, there's all sorts of additional parts. And I guess just for clarification, maybe for staff's purposes, to know which part of that you want drafted into a bill and which part not.
Mr. Chairman, Senator, Section 1, grooming of the child for sexual offense would be what I'm after, and I'd be happy to forward that to LSO.
Very good. With that, I think we'll conclude the discussion of stalking. Being an older person, I'm going to take about a 10-minute break, and then we'll come back and take up the remaining topic of obscenity. Sorry for the delay in my return. All right, our next order of business to deal with changes to obscenity statutes. LSO, you want to give us a quick overview?
Yep. So, Mr. Chairman, 10-01 in the online meeting materials. It's also included in your paper copies, a topic summary on obscenity and stalking laws. Already have discussed the stalking, so I'll go right to the obscenity. The background for laws on obscenity find their genesis in the First Amendment. No law can be enacted that abridges a freedom of speech. The U.S. Supreme Court, though, has said on many occasions that right of freedom of speech is not unlimited. And one of the areas in which First Amendment protection does not apply is to obscene speech. And in a case, Miller versus California, the United States Supreme Court has said that obscene speech that would not be protected under the First Amendment, is limited to works that, taken as a whole, appeal to the prurient interest in sexual matters and a moderate or unwholesome interest or desire that the material portrays sexual conduct in a patently offensive way. And then the third piece of that is when that material is taken as a whole, it does not have serious literary, artistic, political, or scientific value. Mr. Chairman, the remainder of the memo describes Wyoming's law. This can be found in 64301 and 64302. 301 is the definitions that apply. If you look at the definition of obscene in that section, it generally tracks almost verbatim to what the Supreme Court said in Miller for the definition of obscenity. And then 64302 provides the offense of promoting obscenity. Mr. Chairman, then the remainder of the memo discusses other states. And just to summarize, the discussion of the laws of other states includes challenges to those acts. In some cases, those provisions, courts have upheld provisions that promote obscenity or deal specifically with promoting obscenity to a minor. And in those cases, the court has recognized that the definition of obscene in those situations generally tracks with what the U.S. Supreme Court has said in Miller. And those courts have also recognized the compelling interest in protecting minors from exposure or having to deal with that obscene speech. In the cases where courts have struck down laws, one of the prevailing themes are laws that may go beyond what is considered obscene. So, for example, a federal law, when first enacted in the 1990s, it encompassed both obscene speech and what the statute used as indecent material. And the U.S. Supreme Court said indecent gets beyond obscene. That's where the First Amendment will come into play. The court said that went too far, and it did not satisfy strict scrutiny. That current iteration of federal law now targets obscene speech and child pornography rather than the broader term of indecent material. Mr. Chairman, I'll conclude my remarks there, but I'm happy to answer questions if there are any.
Senator Crum.
Mr. Chairman, I've got some questions, and maybe they don't have to be answered right now, but I think if everybody testifying could help me so we don't repeat the same question over and over again. A couple things in my research on this. One is, you talked about the current state law, and it basically says applies to what an average person would think is obscene or objectionable. My question is, what is average, and how do we determine what is average? So really, what is the definition of what does obscene really mean? If we're going to try to enforce a penalty, what are we enforcing it against? So somebody help me with what is average and how are we defining that? And then the second thing is, I know we're going to hear, looking at the hundreds of emails that I've got and some phone calls, we're going to hear about free speech and keeping books open and we shouldn't ban books. And I believe in free speech and all that. But I know in calling several libraries around the state, I find that we already banned books like Tom Sawyer, The Ventures of Huck Finn, Mice and Men, Killing the Mockingbird, The Great Gatsby, Black Boy, which we talked about. It was a book about discrimination and how discrimination hurted people. We already banned some books in our libraries around the state. So what books should be banned and why should we not ban some others? I guess I need some help within. We're already banning books. So the idea that we don't ban books, that's not really a good idea because we do ban books. And so help me with why we would ban a book or not ban a book or a category of books. So those questions on what is obscenity really, what is average, how do we define that? And then and then what are we trying to define here as a group? Because we already banned books in libraries in our state, and I've called them and verified that. So thank you, Mr. Chairman.
Thank you, Senator. So, Mr. Fuller, was the Miller case the one where the Supreme Court said hard to define obscenity, but we know it when we see it? Was that the case or a different case?
Yeah, Mr. Chairman, that description, I believe, I don't recall if it was a majority opinion or a concurring opinion, but that came from an earlier case.
Yeah, those are some of the challenges. Senator Hicks, did you? Nope. Well, any other questions for Mr. Fuller? All right. I'm not ignoring your questions there. I'm hoping that others will answer those questions. So do we have any state agencies in the room wishing to testify on this topic? Wise people. All right. So I'm not sure where we want to begin here. Representative Lucas, you want to come up and maybe get the discussion rolling?
Thank you, Mr. Chairman. Greetings, committee, Mr. Co-Chairman. I have an assistant. He's going to hand out, please, to everybody. Just a visual aid. I went to the Laramie County Library a few days ago and they were wonderful. Kudos to Jillian who helped me find books. I had a list of books. And what I have here are books that were located. I found them in the Laramie County Library, the teen section, largely the young adults, they call it. It is a quasi-restricted section where small children are not allowed in, but there's no doors or people to stop them. So it's part of a big room at the library. Just real quick, Mr. Chairman, if I may, refer to Senator Crum's question earlier. Real quick, the Laramie County Library had a display up 2 weeks ago, and I took a picture of it, and I could send that to you, which says check out a banned book today. And just about every book you mentioned, it was on that display and available for rental from the library. Yeah. We're never talking about banning books. What we're talking about is correctly putting them in the right place so that the correct access is allowed. My whole point on this is that some printed material, some all material, some material is just inappropriate for children. The young adult section at the Laramie County Library goes from grades 7 through 12. And I talked to the librarian. I said, what's a 7th grader? How old are they now? Because, you know, I'm a grandma. She said they are typically could be right out of sixth grade. They went to 6th grade yesterday. Today's the first day of summer vacation. They are now a 7th grader and they're maybe 12 years old. So I'm thinking about 12-year-olds more so than 18-year-olds. Okay. But I've been working on this for 5 years. I'm not going to talk for 5 years though. So what we're talking about here is obscenity as it relates to children. The Miller test says persons, and I've read in some decisions contemporary adult standards, contemporary adult community standards. Nothing in the Miller test says children or minors. And so what we've got is a test of average people, whatever that is, that
determines from community to community what is obscene. You know it when you see it, folks. But it doesn't say, well, what's appropriate for children? And nobody addresses that really, other than, you know, child porn, things like that. But we don't really address what that means in the terms of books. So I have for you some books, and there are some websites who will show you pages that all the nasty stuff is on. Those don't work mostly because different print editions have different page numbers. So I'm telling you that I sat here for the past week and I went through a lot of books and I looked for all the nasty words and I got tired. So some of those books don't have a lot of tape flags, but some of them do. Some of them have pictures, some of them don't. But every one of those, unless there are no tape flags on a book, represent books that have been rated as restricted to minors, inappropriate for minors, or for adult reading. And there's a lot of rating scales out there, and they don't all agree exactly, but like political rating sites, they all kind of come together at the end and the numbers kind of match up. We've asked many times over the past 5 years to have these books segmented. All I'd really like is for the parents to be the person who decides what a child reads. I am the best choice. I'm the best person to decide what my children read. And I don't want my 12-year-old to learn about anal sex or fellatio, okay? But that's what's in some of these books, and I'm not exaggerating a bit. You'll be horrified if you actually looked at some of this stuff. I think a 12-year-old could go a long time in their school career without ever seeing a book like that. People who want these books available freely in libraries and school libraries, I've talked to a bunch of them, and most of them won't let their children read it, but they want your children to. And that makes no sense to me. Every book that you're looking at, by the way, that I got from the library was paid for with tax dollars. Couple of important things for you to know about. I sent you a bill. Thank you very much to my friends at LSO for all their help on this. And it's kind of like the one we looked at last session, but kind of different. And the big changes on that, nudity is gone. Law enforcement asked me, I had law enforcement members review this bill. And they said nudity is hard because, you know, you've got the copper tone kid and every baby butt that somebody posts a picture of on Facebook, and childish things then become sexualized in minds. And so nudity is gone on that. I've simplified a lot of the wording so that it's a shorter bill, it's a tighter bill. And my intent with this is that you have a jumping off place. You know, this may not be what it ends up at, but I know that the appetite in our community is high for this subject, that we have to get this figured out. We need to define what is inappropriate for children and who are the people who are the appropriate deciders. If you don't allow parents, right now, our current statute, parents could be arrested. If I decided I wanted every child in Torrington to read genderqueer and handed it out at the Walmart or whatever, I could be arrested because that is an obscene book. And I am not a teacher or a librarian. I love teachers and I love librarians, and I've talked to a bunch of them, and a lot of them don't agree with the material that is in the contents in the library. So I think we've got something that needs a lot of attention, and I don't know that there's going to be a real easy answer on this one, folks, but I think that you are the folks who can do that. And I appreciate your time very much this morning, and I would be happy to answer questions.
Thank you. Questions, sir? Representative Lucas. Representative Chester.
Thank you, Mr. Chairman. Representative Lewis, good to see you. Two questions. One, I'll try to make them short. Where did this draft come from? Is this a bill that has been adopted in other states that's been tested in court, or is this some other source?
Representative Lucas.
Thank you, Mr. Chairman. Representative Chestick. It is a combination bill. I got parts of it from Arkansas, and I don't have the number off the top of my head. And then I got parts of it from Missouri, and I believe there's a smattering of Kansas in there. My friend in LSO who helped me with this up before last session probably has all my notes. So some of it came from attorneys here in Wyoming. Some of it came from law enforcement, but largely it was Arkansas.
Representative Chestick, follow up.
Were those enacted bills?
Yes.
Okay.
Sorry.
Representative Lucas.
Thank you, Mr. Chairman. You know, I'll get this right in about 3 years. Yes, they're enacted laws.
One final follow-up.
Follow up.
You said that this bill no longer includes nudity. I direct your attention to page 6, lines 1 through 4, which is the definition of harmful to minors. And that's the key definition of this bill, right? Obscenity doesn't matter. It's harmful to minors is the key concept here. And it's defined very broadly. And on line 3, nudity is all by itself a thing that could be harmful to minors. It is still in the bill, right?
Representative Lucas.
Thank you, Mr. Chairman. Yes, you're right. Oops, missed that one. In talking about this, law enforcement was just really firm that nudity is just way too prevalent in our society, and that basically any toddler who doesn't have a shirt on could be considered to be partially nude. Some of the state's bills really go into excruciating detail over descriptions of nudity. And the feeling was that if there is a problem with nudity, that it is probably a problem that is recognized under other parts of statute, and that they didn't really think that was an issue. But yes, you got me on that one. I didn't get that one out of there.
Representative Singh.
Thank you, Mr. Chairman. Representative Lucas, how would you describe the difference between something that is purposefully obscene and written as a piece of art as compared to something like a dictionary or an encyclopedia, which is trying to categorize in a scholarly way?
Representative.
Well, the words prurient comes to mind, that it's intending to excite sexually, lewd, with the intent to excite sexually. People say, well, then David, the statue of David would not be permitted. And that's another reason for getting rid of nudity, by the way, is that we do have a lot of classical art that has nude figures in it, and they're not sexual in any way. But David is not in an excited condition in that statue. And so more towards art. Also, it has artistic value. And some books, of course, will discuss, maybe there is a mention of sexuality in there or a sexual action, but it is not excruciating in detail or intending to excite one sexually, and has literary value. And there are many, many books like that, we could just sit here and name off a bunch and you go, yep, I had to read that one in school. Did that answer your question? I kind of wandered there for a moment. Sorry.
Thank you, Mr. Chairman. Just as follow-up, and just looking at the different books, some of them are depicting a scene or whatever, and then there are books that are trying to categorize almost in an informational way as an advocacy of their particular lifestyle. And so treading the line between the right for anyone to express themselves with the First Amendment, but also making sure that children are safe from harmful materials, that's a line that we're treading. So I'm just trying to be aware of that.
All right. It's 11 o'clock. We've got till 12:15 for this topic. I think there's a lot of interest in this topic. So who else in the room would like to testify? Okay, why don't you, three of you come up and we'll just work down the row. Sure, Representative Lee, I'm sorry.
Thank you, Mr. Chairman. Thank you for coming today, Representative Lucas. My question would be, as an obscene test, would you agree that a common definition might be something that you couldn't read in a public meeting?
Oh,
Representative Lucas.
thank you, Mr. Chairman. Thank you, Representative Lean, because that reminds me of how I got started on this. I attended a school board meeting 5 years ago, and parent got up and read a section from a book that is now not allowed in the Laramie County School District 1 libraries. And she was stopped immediately by one of the board members and said, "You're not permitted to use language like this because our meetings are live streamed to YouTube, and YouTube has obscenity standards, and this doesn't comply with that, but it's okay for the children's books." Yes, I do agree with you, though, to answer your question.
Representative.
Thank you, Chairman. Representative Lucas, I was just wanted to make a comment. Earlier, we led out with the stalking issues, grooming issues and things. And I think that set the stage for the importance of protecting our children. So, and then you also mentioned the concept of these books are all paid for by the taxpayer. And the homes they're housed in, our libraries, are also funded by the taxpayer. So I just wanted to say that with our minds in our attempts to concentrate on our youth and to protect their mind and their spirit, their bodies, I look forward to continued discussion on this, but thank you for your comments.
Mr. Chairman, final comment?
Final comment.
Thank you, sir. I'm just going back to Representative Singh's question, and he was really going with nonfiction and fiction. It sounded like more of a reference material, maybe with depictive drawings and graphics. And there are a few of those books on your tables. And then a lot of the bodies of work you have there are fiction. They're stories. They're not necessarily true stories, but they're stories. And I know, there's a popular segment of literature out there, romance novels, for example. There's a category called chick lit, and it's largely just light romance novels, and they sometimes get a little sex in there, but it's usually just kind of fluffed up and not a lot of graphic detail, because I don't know, a lot of folks don't like to read that stuff. But I don't know, though, that it is appropriate or the job of a government agency, and our libraries and schools are government-run agencies, to provide this type of instructional material without parental consent. So if we're going to opt in, and make parents send permission slips for this, not to opt out, but to opt in. You want your children to get this material, then that's one thing. But we don't currently have that in any of our communities. We don't have opt-ins, we have opt-outs. And that means unless you say something, your kid's getting this stuff. Just my final comment. You folks, I appreciate you so much. You've got a lot of work to do on this one.
Thank you. Representative Lee Byler.
Thanks, Mr. Chairman. And I know we're trying to hurry this through, but I do have a couple questions for Representative Lucas. First, and these ought to be real simple, quick. First, can you show me where the information is that these books were all paid for by our tax dollars? And secondly, would you agree that most people go to a library or a public library for a specific issue and not just willy-nilly just to go and just look at books all day? But I think most people, when they go to a library, they're doing research or whatever it might be, but they're there for a specific issue. And then, I'll just throw one more question, Representative Lucas. When we talk about schools, the opt-in, opt-out, when I register my child for school, it allows me to opt in or opt out on certain things, and also allows the notification for any instruction from the teachers for my children already in Laramie County School District number 1. And Article 7, Section 11, I would like you to explain how this fits into our Constitution when it pertains to textbooks. Sorry, Mr. Chairman, that was a bunch. I was just trying to get them all done in one shot.
Thank you, Mr. Chairman. Representative Filer, I wasn't able to take a lot of notes on that, and I'm going to need some help, folks, with the Constitution, because I didn't bring it with me and I don't have the whole thing memorized yet. So I would appreciate some reference on that. First off, as far as tax dollars go, some of the books that you have there are from my own personal library. Thank you very much. Some of them, most of them are from the library. And if you flip it over and look at the back cover, and it says paid for by 1% tax. And if it's my book, it doesn't say anything because I paid for it out of my own money. Specific issues, well, I guess it depends on what you're used to using a library for. I have a grandchild who's 5 years old, and he loves to go to the library. And when we go there, we're not researching anything. We're just going there to have a good time. He loves the library. He's 5. He reads like he's in 4th grade. Okay. And we go there and he has a blast. He plays on the computers. He plays with the Legos. He goes and he rummages through the bookshelves. And I have, by the way, folks, a stack of books over here that are from the young children's section of the library, and they're not dirty books, but they pertain to categories that perhaps not everybody in this room would agree with, but they're by, if we look at sex, they're classified as clean books. So I think that depending on what you're going, I go to the library, I'm looking for something specific, but I don't have the time or the need to spend time at a public library for leisure reading. My lifestyle is a little different right now. I read a lot of the stuff you guys read. And mostly I get all of that from either Green Books or the internet. But I think it depends on where you're at in life and what your goal is. When I was a child, I could go to the library by myself. 8 years old, walking down the streets of Chicago. I grew up in Chicago. The neighborhood library was right there, and I could go to the library by myself. My mother went when she needed to tell the librarian to let me take more books out because they had a limit and they'd only let you take out 4, and I needed more. But my mom trusted that I wasn't going to get anything harmful at the library. And now people say, you need to watch your kids every minute they're in the library. You need to monitor what your children check out, and you need to control what they read, and you need to basically curate their reading materials. And if that's the case, why do we have librarians? Are we saying that the library is not safe? I hate the thought of that. The library is such an enjoyable place. I love it. Thank you, sir.
Thank you. You want to address the last question on the Constitution?
Oh, yes. May I have a few seconds, please? Can you repeat that reference?
Representative Filer?
Yes, Mr. Chairman, Representative Lucas, it'd be in their page 39, but it's Article 7, Section 11 under textbooks.
Representative.
Thank you, Mr. Chairman. I'm not talking about textbooks. You don't have any textbooks in front of you. I'm talking about books that are in the children's library. There are textbooks in the library, but I'm telling you, I didn't see any the other day in the children's library. You know, they don't have Dick and Jane reading books there. They have books that are for leisure reading or learning, how-to books.
Very good. Thank you.
Thank you, sir.
Mr. Mullen.
Mr. Chairman, members of the committee, my name is Tate Mullen. I'm the Government Relations Director for the Wyoming Education Association. I want to start my comments by addressing Senator Crum's question of, which books to ban or why. And I think that isn't really the question that we need to be asking, and instead focus on what processes are in place. Is the system currently failing as it is right now? I want to be able to provide that context in terms of our public education schools, and our classrooms. So I have worked really hard to prepare for this meeting, but by meeting with a number of classroom teachers, librarians, as well as administrators. Our educators share the value. I want to get that point across crystal clear, that we want to keep our students safe, right? We want to keep our children safe from harmful materials, but the work and processes that are in place regarding curriculum and library materials, they're rigorous, they're effective, they provide multiple opportunities for public comment. We do want parents involved. They have multiple opportunities in multiple aspects throughout the process of the adoption of curriculum or materials within a library, or to discuss the policies within school districts regarding those adoption of materials. So an examination implies that there's a problem that hasn't been resolved. Simply having some people who object does not necessarily demonstrate that it is a problem without resolution. In fact, that resolution can be found and has been found at our local level. Just because the resolution may not appease some constituents doesn't invalidate that resolution. We're not going to be able to please all the people all of the time. However, what again is of vital importance is that the process is open, transparent, fair, provides multiple opportunities for input, and that local decision, again, to your point, Senator, that contemporary community standards. Our communities across the state are not homogeneous, right? They vary. That's that input that we need. And that's that input that is currently available. Again, throughout that adoption process, the ability to challenge books, the ability to discuss curriculum throughout our schools. I do want to get to some of the issues within the bill. Anyone that has any managerial or an administrative experience knows that if you have great employees, they're an invaluable asset, because as managers or administrators, you can have an idea and they go, hey, boots on the ground, I'm going to tell you how this is actually gonna go. Two of the issues that I've heard continuously.
Let me interrupt this moment. So what you have before you is not a bill draft of this committee, just so you're clear.
Mr. Chairman, I appreciate that, but just in the general context of what we might be looking at, or last year's bill. So because any of the bills that we've seen previously all have the same general issue. One is going to be the chilling effect on education. Senator Crum noted a lot of the books that are out there, right? To Kill a Mockingbird, The Great Gatsby, Shakespeare, right? So Romeo and Juliet, Midsummer's Night Dream. Within the language in last year's bill, Walter the Farting Dog, which I read to my son as a kid, would qualify. Shel Silverstein would qualify within the language here. The other piece then is the chilling effect that it is going to have on one of the legislature's biggest topics is recruitment and retention. If the enforcement of this is arbitrary, right? Who decides that, right? So as it is now, we have a system in place that we work through this chain of progression. We involve communities, we involve parents, but bills like this, what they allow for is a parent to potentially contact law enforcement. And in that circumstance, law enforcement is the arbiter, not a professional librarian, not a professional educator, of what material qualifies as obscene in this bill. That is, you think we have problems with teachers applying for positions now? The prospect and the vagueness and the arbitrary enforcement of this is going to have a chilling effect on those applicants. So there's a ton of other pieces that I wanted to go into, but I know we have a lot of other people that want to offer public comment. I did, in those conversations with educators, librarians, and administrators, have them walk me through their process for curriculum adoption, library materials, classroom materials. If anybody is interested, I would be happy to have a conversation with you and share that. But every district has those policies and they work. So with that, I'll stand for questions.
Questions for Mr. Mullen? Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today, Mr. Mullen. Would you agree that sex acts and graphic detail like ejaculation on another person have no business in a school library?
Mr. Mullen.
Chairman Washit, Representative Lean, I am not the decider of that. That is a local decision that needs to be made at the community level with the parents, the community members, the educators, and the students within that community. My opinion of that is irrelevant.
Follow up.
Thank you, Mr. Chairman. Thank you, Mr. Mullen. When it comes to situations like that, do you believe that parents should be an opt-in versus an opt-out program?
Mr. Mullen.
Chairman Washit, Representative Lean, I believe that that is a decision that parents have the ability and should have the ability to make in conversations with their local school boards in those opportunities for public comment.
Thank you, Mr. Mullen. Next.
Thank you, Mr. Chairman. I'm Lindsay Travis. I am the president of the Wyoming Library Association. I just wanted to talk for a few minutes about parental oversight in our libraries. Our public libraries, our school libraries have a lot of parental oversight. That is what we focus on. We have policies in place so parents make the decision on what their kids check out, not the librarians. There's not one librarian out there that is forcing anyone to check out any book. Parental permission is required for library cards. There's an ability to link library cards for parents to easily monitor their children's checkouts. Policies state that parents and guardians and not librarians are in control of what their children check out. Policies also allow patrons to request reconsideration or challenge any material within the library collection. And state statute already allows parents to inspect the library records of their minor children. Some school districts also have opt-in and opt-out policies for their school libraries. Our libraries are under local control. The public libraries are governed by a board of directors that is appointed by the county commissioners. They're the ones who are in control of the policies. They're the ones who write and approve the policies. Those policies are written within a public sphere. They allow public comment. Nothing in the library is hidden. Everything is out there for the public to comment on. I also wanted to comment a little bit on this draft bill. I know that it was mentioned that it was based on the Arkansas bill. That was found, parts of that bill was found unconstitutional by a district court. So that just might be something for this committee to take under consideration. The Wyoming Library Association encourages legislators to visit their local libraries and see how they're governed, to see all the services that we offer and see how we empower parents. We are happy to provide information and education, and we thank legislators who have already done this. Many of the books also that Senator Crum had mentioned that are listed as unavailable or that weren't available in libraries are available digitally. So if they weren't in the library, we have them digitally and throughout the state. I will stand for any questions.
Ms. Travis, is it still possible for children to peruse books in the library without checking them out and then not be detected by their parents because they never checked the book out?
Mr. Chairman, yes. However, it is a parent's responsibility to know if their child is wandering around the library on their own.
So should we make libraries no unsupervised children allowed?
That would, Mr. Chairman, that would be a policy that would be approved by a library board. So that's a local decision that parents and other patrons can come and comment on.
Senator Hicks.
Mr. Chairman, thank you, Wendy, for coming today. Could you, where did the source of the books come for our public libraries? I mean, who sources those? Does each librarian in each county library go out? So I'm just curious as to where the source of the books come that then our county libraries put in our buildings. And so if you could just walk me through that process and where the sourcing of those books and then what steps are gone through to screen those books at any level for obscenity before they go into the county library. But could you walk me through that process, please?
Ms. Travis.
Mr. Chairman, to answer that question, every library does it slightly differently. We all have a policy that oversees our collections. So I can tell you what it looks like in my library, where we have people in different levels of responsibility give suggestions to our collection development specialist, who then purchases books. Our collection development specialist also researches books through different avenues to figure out what is currently trending, what people are reading, what topics we're missing in our library collection. And then we also take recommendations from the public. And the public can recommend that we have a book if we don't have it and ask for things specifically. After those are brought in, they are then cataloged by our cataloging departments, and then they are sent off to the different departments that they are going to be shelved in, where the manager of that department then checks that book to make sure it fits where it's supposed to go, and then we shelve it.
Follow up?
Follow up, Mr. Chairman. So let's talk about sourcing the collections and then how that's done. And within your membership and within the county libraries, we're talking public libraries, not necessarily schools at this time. Is that primarily through the Wyoming or the American Library Association, or is there any other organizations that supply those approved lists that you know of that are currently being used in the state of Wyoming?
Ms. Travis?
Mr. Chairman, it depends on the library, but the American Library Association does not have any oversight over libraries. They are just a professional organization. Items are selected based on research. There's different publications that are out there that do recommendations. But the American Library Association does not oversee us at all.
Ms. Travis, is the library board, when you gave us that list a little bit ago, you did mention the library board. Does the members of the library board actually see the books before they're approved or put on a shelf?
Mr. Chairman, library boards don't usually look at all the books, but they can if they want to. They approve the policy that we are purchasing books under.
Mr. Chairman, just one more follow-up and then I'll
Senator
turn over to somebody else on this subject. So appreciate you get edifying for me, this process and stuff. And I think it'll come into some discussion later on the bill. So as I understand it, and correct me if I'm wrong, it's primary responsibility of the library for each one of those county or public libraries to order those books, do the research, and them and their staff, and then they agree on them. I want to know who's responsible for ordering those books that are going in there. That's what I'm trying to boil down in, is who's responsible and where are they getting the information from to order those books for our public libraries.
Ms. Travis?
Mr. Chairman, overall, it's the library director's responsibility for the entire collection. They then give that responsibility to members of the staff, but ultimately it is the library director's responsibility to oversee the collection.
Thank you.
Representative Shuster.
Thank you, Mr. Chairman, and Ms. Travis. Thank you for being here. I just have one simple question on the bill draft that we were looking at. The last couple pages have a challenge provision if somebody wants to challenge a book, and there's a process. And there's if the challenge on the last page, page 8, it says that if the challenge material is determined to be obscene or harmful to minors, it must be isolated in the adult section of the library. I wasn't aware that the libraries have adult sections. If they do, how is that enforced? And do you foresee any problems with enforcing having an adult section of a public library?
Mr. Chairman, libraries are divided based on their genre. So we have adult fiction. So that is fiction that would be for adults, and adult nonfiction that is for adults. That just means that that's the intended target audience. It would be a problem, I think, to move something into an adult section, but that depends on the library. The items would still be available to whoever wanted to check them out.
Representative Kelly.
Thank you, Mr. Chairman. Thank you for being here. I view this as a collaborative effort to deal with something. I don't view this as a win or lose situation. So what's helpful is to understand where we all stand on these issues. I've read this column here that says prosecuting librarians is not the way to go, and I agree with that. I don't believe there's no intention on my part to make criminals out of librarians in any way. But there's a quote here I'd like to ask you about. It says, "Any law or policy that denies people of any age equal and equitable access to library resources raises First Amendment concerns." So just to clarify, Are you arguing that age appropriateness is an invalid concept? On the idea that there should be equal access for any age to any material?
Ms. Travis?
Mr. Chairman, when it comes to that statement, I would say that the First Amendment applies to all members of, all citizens of the United States. So that's where that comes from. Parents ultimately have the responsibility for their own children. It is not a librarian's responsibility to make sure they to monitor what they're reading.
Representative Lean.
Thank you, Mr. Chairman. Thank you for being here today, Ms. Travis. I appreciate that you recognize the parental rights when it comes to the libraries. My question has to do with hustlers and cosmopolitans. Would you ever find those in a young adult section of a library?
Ms. Travis?
Mr. Chairman, we definitely don't have pornography magazines in the libraries.
Thank you, Mr. Chairman. Based on that last comment, I have two questions on the Libby system, if I may. Ms. Travis, and we had an opportunity to meet in Green River and have some time. On that last comment, you're saying about obscene. So who made that determination on these magazines that were just brought up?
Mr. Chairman, we don't have anything that's legally porn in the library, so you wouldn't find Hustler magazine in the library. Cosmopolitan you might find in the adult section of the library, but definitely not of Hustler.
Okay, because you and I did speak about Hustler and Playboy and such. So anyway, if there's a rating of being obscene, that same rating should be able to be applied to books, in my opinion. But I have two questions on that Libby system, if I may. Are there any age restrictions using the Libby system online? And can you prove there are no materials with prurient interest in the Libby system?
Mr. Chairman, the Libby system, just like the library, it requires a library card in order to sign up to use that. So that means a parent has to give their child permission to use it. There are ways to filter out items that are appropriate for kids, and nothing in Libby would meet the Miller test for being obscene.
Okay, thank you, Ms. Travis.
Thank you.
You can turn your light off, please. There you go.
Thank you, Mr. Chairman. I have some papers to hand out if that's okay.
You need to introduce yourself
Oh,
first.
yes. My name is,
And give the handouts to the LSO staff that have to see them first.
okay. My name is Chelsea Collier. I'm from Campbell County and I'm on the library board.
Please be brief for it.
Okay. Try to be quick. Thank you for this opportunity to speak. And I didn't meet with the House Judiciary when we were in Cheyenne. And so I'm thankful for this opportunity to be before the senators as well. I'm handing out a packet today. I've been on a library board in Campbell County for 3 years and I just applied to re-up that position. And so I'm looking forward to continuing to serve my community in that capacity. I do see what the previous speaker was talking about with in regards to library boards and local control. However, I want to point out in my speech today about why we need your help. This is beyond local control at this point. So in your packet, you will see on the first few pages an article that's been put out by a company called Brave Books. And I'm an advocate for Brave Books, but I'm not particularly in line with them on everything here. And you'll see here in their article, they particularly disagree with all LGBTQ information. And I think we need to weave the needle carefully here when we create this legislation, because this isn't about LGBTQ, this is about sexually explicit. And so you'll see here that you're going to have people that say we're trying to ban all LGBTQ information, and that is not the truth. We are talking about sexually explicit in Campbell County alone. I cannot speak for the board, but just my own experience. We have kept the book. It's called Desmond is Amazing. It's the history of the trans history in the children's section, and we have also kept the Heather Has Two Mommies book in the children's section. So people have brought these books and we've gone through this challenge process, which is effective. But I want to point out to you that on the page 5 in your packets, it looks like this. This is what our WILD website looks like. And so when you go online to request a book, and your librarians are so wonderful about putting those on the shelf at the front door if you can't go in for very long. So this is what it looks like. In Campbell County, we have this book. It's called Welcome to St. Hel, My Trans Teen Misadventure. Now, no one's ever challenged this book, but it came up in the article I read from Brave Books. And so I just looked to see if we had it in our library, and sure enough, we do. So if someone wanted to challenge this book, they could, because we have a paper version. But then you'll see below here, it says checked out. We have an e-comic version and a Kindle version, and you can place the holds on Libby. I'm not sure if all of you are familiar with Libby. I love Libby. Our family uses Libby all the time. We check out Henry and Mudge, the paper version, and then we get the audio version, and my 8-year-old listens to Henry and Mudge, and it's wonderful. So Libby is a resource. I'm an advocate for it. However, my 8-year-old can also use my Libby app and literally type in erotica and listen to audible porn on Libby. And so I just am saying there is no opt-in, there is only an opt-out, and Libby is not regulated. The new bill about age verifications, I've been told, does not relate to Libby because of the obscenity law is an exemption for libraries and schools. And so we need to make some changes here to specify specifically about this. And I think it's a hard cop out to ask parents to sign something when they think their kid's getting a library card. I have a picture here of a 3-year-old. They're so excited because they get their first library card, right? And little do their parents know that on Libby, they can Google erotica just by having it on their device. I was before Governor Gordon during the legislative session, and a mom was sitting next to me. She's like, oh, my kids have Libby on their phone. Of course I would let them have Libby. And I'm like, do you know what's on it? And she didn't know. And she was shocked. And so was the governor. And so I just ask that you look carefully in the wording, that it's not just about hardback books, but as a librarian, or as a library board member, I can regulate what is done with this paper book and where it's put in the adult section, but I can't regulate the online versions. These are regulated by the state. They're a state funded book, not a Campbell County, Wyoming book. And so I'm just asking for you to really step in here and be the middleman. In addition, in this packet, I included an article that I included previously from CBS Cowboy State Daily. I went to copy and paste it into Google Docs, and they wouldn't let me transfer the images because they said they're too sexually explicit. So regrettably, you have like little icons for pictures. I did not do that. That is Google Docs having regulations about pictures, but I did paste one here for you. And so I just don't understand how this isn't considered sexually explicit. This is awful information. And this book is called Genderqueer. And in Campbell County, it is now in the adult section. So each county has to go through this process. I also think it's labor intensive for the people. You're asking people who are just regular old citizens to read these books. I'm paying a library director 6-figure salary. And you're asking citizens to go and find these books and challenge them and go through this rigorous process. And then they have to hire civil counsel for, to go through a court system possibly. I just think it's a ridiculous expectation. And so we need to have more regulations from the state to help us on this level with even purchasing these materials and putting them in children's sections. Finally, in my packet, I have something here I used to help formulate our collection development policy in Campbell County. It's the Sex Act definition from Iowa Code. It is horrendous to read aloud. I've had to read it aloud at library board meetings, and I'm not going to read it to you, but it is in your packet. And then, and that wasn't in the memorandum that I read at the beginning of the meeting. So that was also in there. This is also not in your memorandum. This is Alabama. They have a different system. They have a a library board for their state in Alabama. And so that library board has said you will not receive any funding in our state if you have a sexually explicit book in the children's section in the state of Alabama. So we can't do that here. We have a regulation, a statute that says all libraries must be funded in the state of Wyoming. And I appreciate that. I appreciate my library. I go to my library more than just to research. My children and I are homeschooling family, and we use the library liberally. I constantly go over my 35 checkout limit, and my librarians are gracious to me. And I have paid quite a few fines because we've lost a few things, but I'm always happy to participate in the process. And I'm open for any questions. I truly am invested in this, and I would like to see it through. Thank you, Mr. Chairman.
Ms. Carter, thank you for coming down today. Can you tell us a little more about this Libby system? Is that a state-funded system? Is that part of the library process? Tell us a little more about that.
Yeah, sure. So Libby is an app you get on your phone, and I'd encourage all of you to download it. It just takes your library card, and on there you can find, here are the books I have on hold, but then on there you can also find your favorite CJ Box book and Craig Johnson book, and my husband's on hold for like 28 weeks for the next CJ Box book. So I mean, you're just competing with other counties here, but in the top here, I hate to destroy my algorithm here, but here, if I type in erotica, I can get best women's erotica, the Tuesday Erotica Club, best women's erotica of the year. These are all books I can read as well as listen to on Libby. And a lot of families just don't know. And so I just want to encourage, like, just inform parents. Like, yes, we want parents to decide, but parents need to know. Like, when they sign up for a library card, they think this is so cute. Oh, my kid's 3 and they have their own library card, and I'm going to download, these apps so they can listen to books, and then they don't even realize what information they could be exposed to. So it's a free app. It's so great. It's like Audible, but I just wish it had some regulations on it.
Representative Filer?
Yeah, thanks, Mr. Chairman. Ms. Travis, thank you for your service on a board, especially on a library board.
Thanks.
But with that app, I've been saying this for the last couple of years when it pertains to this, is a lot of the online is where the problems that we're really having. It's not necessarily a young kid just going out to check it out book, because yes, as parents, we can control that a lot better than we can on an online. And this committee, at least on the House side, we did pass laws for age verifications and different things like that when it comes to certain apps and different websites and all that. So what I'm asking you is, as a board member of a library, would you be in favor of us maybe looking into that more than just saying, the constitutionality of First Amendments and everything else, but maybe allow that more parental control? Let's instill that instead of just blanketing, making criminal charges or anything like that.
Thank you for the question.
Go ahead.
Chairman, thank you. I think there needs to be a lot here that needs done. I'm sorry not to just corner it down to Libby, but I am in favor of doing something about Libby. But I do know that kids, I pulled up a statistic from the Institute of Family Studies. It says 93% of boys and 63% of girls report being exposed to internet pornography before the age of 18, with the average age of first exposure being 12 years old. So children are exposed to pornography at a young age. I know that obscenity gives us a lot of guidelines, but I think we need to narrow it down even further, because obscenity is the Miller test, which was created for above age 18. And we're not talking about that, right? We're talking about kids. And when we go to the movie theater, my kid can't go into the rated R movie. We have to sign something for them to go in, right? And so there's regulations for kids that are different than regulations for adults. And so I think that's why we need to look at these definitions that the prior speaker put in the statute, and then some I added at the end there from other states, because this process of asking a patron to go through all of this and refute it back is just too much to ask of a patron. We need to hold our libraries accountable, and they need to be curating collections that honor children and honor families and give them good guidelines. Thank you for the question.
We have about 35 minutes left. Any further questions? Senator Craig?
Mr. Chairman, Ms. Collier, thank you for being here. Quick question on the criminal penalty side. As a board member, how do you feel about the criminal penalty regarding librarians?
Ms. Collier?
Thank you, Mr. Chairman. I don't think librarians need to go to jail. What's interesting about this process is that as the previous speaker was saying, in the process of acquiring books, I actually worked at a library for a year. I know librarians don't look through every book, right? There's no fathomable way they could do that. So I know that there needs to be a system in place. And we can't just put librarians in jail for giving kids information. However, this process says that I think it says 60 days. So it's been brought to their attention, right? Like it's not just some willy-nilly thing. This is brought to their attention. It's gone through the board. And so at that point, it's like, you're ignoring the problem. And if someone is giving you a definition of a sexually explicit or sex acts, whatever you decide, then at that point, it's beyond ignorance. You've been asked and you're ignoring.
Follow-up? Follow-up. Thank you, Mr. Chairman. So as a follow-up to that, as a board member, do you think that responsibility and potential criminal liability should also fall on you?
Ms. Collier?
If the information has been brought before me and in statute it says this is the definition, then yes, I should be held accountable. Unfortunately, I'm also being held accountable in other ways right now that you might know, but there is consequences to our actions, and when there is a law, we must abide by it.
Okay. Representative Lean.
Thank you, Mr. Chairman. My question has to do with House Bill 43 on age verification for minors. On page 3, in lines 16 to 22, it says that it intentionally includes any electronic services provided by libraries or educational institutions. So I'm wondering where we got the information that this does not include the Libby app.
Ms. Collier?
Thank you. Thank you for the question. I was informed that in our obscenity statute, there is an exemption that is only for librarians and teachers. And so I didn't think it would follow through there. And so I think we just need some fluidity in our statutes.
Okay. Is there anyone else? How many other people in the room might wish to testify on this topic? If you just raise your hand. Anybody else in the room? All right,
Get them high.
Representative Brady.
I see one.
Thank you, Chairman. This is for Chelsea. I have a question. In your research, what role, if anything, does the American Library Association play regarding this topic? Do you have anything to contribute there? Thanks.
Ms. Collier.
In Campbell County, we passed a rule that we would not support the American Library Association being over our library. Our library foundation still pays for our employees to attend their events. However, we have found that a lot of the information that is given through the American Library Association encourages purchasing the books you've seen here today, and does not equally encourage other books, other materials that could be valuable. And so when a library buys a book, it gives it credence. And the American Library Association holds a lot of credence in our state because they're an avenue for people to go to choose the materials. They don't give us permission to choose them, or but they give recommendations through things like Book List and other resources that you have at these little handouts or booklets that they pass out all over the state. And then our librarians look through those, and that's how they choose. And I just don't think that's fair because it excludes so many other publishers and so many other resources. And we should be acquiring books from more than just those places.
Representative Bratt.
Thank you, Mr. Chairman. So we received a handout on the content-based rating. And so this is one generated by books.looks.org. And I'm wondering, are there other, I'm sure there are other content-based rating sites? Does the ALA recommend some of those? And do you use that does your school board use some sort of content-based rating? Maybe if other school boards do, to decide if they're going to put a book in what section, young adult, children's. Can you help us understand a little bit more about that? Thank you.
Thank you. The book is chosen where it is placed based on where who the protagonist is and how old they are. So the genderqueer book that we talked about earlier that I give you pictures of, that book, the protagonist is an adult. So it's placed in the adult section. And so originally in our library, it was placed in the young adult section and we moved it to the adult section. And so librarians choose where a book is placed based upon the protagonist. So however old the main character is in the story. But then that rating thing, I tried to create our own rating group in Gillette. And we brainstormed and hashed it out, and we just don't have the resources to create a rating system like that. However, booklooks.org recently changed to a different name, and I'd have to get you the name. But it is a good resource. Parents went and wrote reviews of these books. And so then you're getting information straight from parents line by line to help you dissect the books. So it is a good resource, much like Common Sense Media or something like that to help you research.
Thank you so much.
Thank you.
Anyone else in the room wishing to testify on this bill, this topic? Please come up. Representative Webb.
Thank you. I'd like to ask a question. And that is, you mentioned the exemption. My understanding is those exemptions were probably made in the 50s and 60s, maybe the 70s. Do you know anything about that when our statute that provides that exemption was?
I don't know that.
Ms. Collier.
So sorry. I don't know the exact date of when they changed that. And so I would have to research that and I could get back to you.
Thank you, Mr. Chairman. I think that's something we need to take
Follow
into
up.
account too.
Okay. Anybody else? Senator Cradle?
I was just gonna say, I pulled up the statute. I believe it's 1982.
Thank you so much.
Thank you for your time.
Good morning. Please introduce yourself and tell us what you want us to hear. Please be brief.
Thank you, Mr. Chairman. My name is Danielle Kloss. As a parent, I love our library here in Goshen County, just the way it is. The current system supports my right as a parent to choose the right books that support the values of my family. And it is my and my family's right to decide what is acceptable, no one else's. When the library does not force me to get books that my family does not want. If others get to decide what does and does not get to be in the library, my choice goes away. I want to keep my right to decide.
Thank you.
Thank you.
And say your last name for me again.
Kloss, Danielle Kloss.
Questions? Representative Kelly?
Thank you, Mr. Chairman. Would you be averse to classification systems that were just more informative and explicit? We're not talking about removing materials as much as making sure that parents are better informed on where they are and what's in them.
Yeah.
The classification system seems like it's well thought out to me. But something that says more information is not a bad thing. I just don't see how there's anything wrong with the current classification system.
Representative Filer?
Thanks, Mr. Chairman. I was going to ask too, along this lines of Representative Kelly, but even the electronic side, would you be opposed of being able to have that choice as a parent where you can opt your children out of certain books or know immediately if they try to check out a book or even online, not more of a restriction, but just to give the parent more knowledge of what is maybe content and what their children are checking out so you have a better choice. Would you be opposed to anything like that?
No, I think that is a good idea to have maybe a way that you can have a child setting or something like that on there. I think that would be a good idea.
Thank you very much. Anyone else in the room wishing to testify? Please come forward. Do you have anybody on Zoom? Okay, we'll grab them next. If you want to queue them up. Please introduce yourself to the committee and be brief, please.
Okay, I'm Zach Cook. I'm from Cheyenne. I'm just representing myself. I worked at the Laramie County Library for several years, mostly as a shelver, just shelving books. I'm very familiar with all of the books on the shelves, I'm also very familiar with just how integral to our communities libraries are. They're very, very important to the state of Wyoming. We have a long, rich history of public libraries in Wyoming. Laramie County Library, I believe, is one of the first public libraries in the country. But I guess I want to talk about just, as we talk about kind of librarians and it's been brought up, why do we have librarians and things like that has been mentioned earlier in this meeting. And as we speak today, there's an event going on in every county in the state, and it's Wyoming Reads. And there are thousands of first graders, Wyoming first graders, in our libraries right now all across the state, and our librarians are swamped with kids, and they're getting books and they're learning to read, and it's a great event. And I think some of the people on this committee have participated in Wyoming Reads in the past, and it's just disheartening to see librarians be targeted and being, having discussions about potential criminal penalties for librarians that are just doing their jobs and trying to provide information and provide access to materials and, that anybody can enjoy. And it's been mentioned, librarians are not forcing people to check out books, and that's true. I guess to go to kind of an earlier question that started off this topic, who's the average person who makes that decision, who decides, and it's kind of each of us, right? It's not really the government that decides that. The government's not the average person. Each of us parents are, right? Parents can decide that for our kids, but each of us can decide that for ourselves. So when we talk about the idea of, segregating out books or deciding this isn't good or this is bad, and, potentially removing books or segregating them or closing them off or deciding this is harmful and this is not, it's not really the government's job to do that. It's kind of us as individuals to do that. So, the libraries kind of serve the purpose of providing that information and allowing access to that. And each person who uses the library, that's the average person, and they're the ones that kind of get to decide what information they're consuming or what information their parents or their children are consuming. And I don't think we need to really change that to take that away from people. And I guess that's kind of my main point there.
Appreciate your testimony. Now, would you agree that when these first graders go to the library today to get their Wyoming Reads book, I, by the way, sponsored the Wyoming Reads Day legislation, that when they walk by a display of some of these books on a shelf or on a display rack, that the library as government has made a decision to display that material to those children. So the library has made a decision about what kids can see, even though maybe it's just the cover. They're promoting it as government to children. You see that?
Just putting a book on display doesn't necessarily mean you're promoting something specific or even agreeing with it. It's just, there's a book out there for everyone, right? And there's books out there that are not for everyone, obviously, right? There's plenty of books I don't like, and you don't have to pick that up. And I don't think just displaying it is the government telling you like, hey, you should read this. Just because it's on display and accessible doesn't really mean much. It doesn't mean that the government is making some sort of decision for a child you must read this.
Co-chairman.
Mr. Co-chairman, yes. So do you think that it would be appropriate to have a Hustler magazine on a display rack in a library?
No, I don't think that's appropriate, but that also, a Hustler magazine would meet the Miller test of obscenity. And
Right.
that's,
So there is a standard where government does decide at some point what to display and what not to display in our public libraries.
sure, but a Hustler magazine is, like I said, it's a pretty narrow and specific thing that meets that very narrow definition of obscenity that already applies.
Mr.
So-
Co-chairman, have you read Genderqueer?
I have not read Genderqueer.
I would invite you to take just 30 seconds and look at this
Have you
book
read
and-
the whole book?
I would invite you to look at the pictures in this book
Sure.
and help me to understand how that's different than a Hustler magazine.
So sure, I can do that. But I'm going to ask you in response, have you read the whole book? Because it's very important. And this is kind of interesting because in one of the prongs of the Miller test, right, there's the wording is taken as a whole, the work, right? And so sure, if a book has lewd words or bad pictures or something like that, that doesn't automatically mean that it's obscene under the Miller standard, right? So if you take the book as a whole and you all have books on your desk that have been passed out to you and all the naughty bits are bookmarked, and that's fine. You can take a look at those and make your decisions on what those pictures are, whatever. But I encourage you all to read that whole work, because that's the test, right? The test is not, are there naughty bits in the book? The test is the work taken as a whole promoting the prurient interest, right? It's taken as a whole. It has no artistic or literary value. And I can tell you that none of those books meet the Miller standard of obscenity, because taken as a whole, they're literary works, they're works of art, they're nonfiction, as has been mentioned by the person who passed those out, right? So sure, there are naughty bits in books, there are things that are offensive, but that doesn't automatically make it obscenity, and that does not make it, should not make it a crime. The government should not be penalizing or criminalizing librarians or anyone simply for those books being on the shelves and being available to people who might enjoy those books.
Thank you, Mr. Cook. Further questions? Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today. Just as we restrict movies with age verifications for N-17 and R-rated movies, do you agree that we should do the same for books?
Mr. Cook.
Can I just answer really quick with a question? Is there a law that restricts those? Is there a law on the books that actually restricts children from attending R-rated movies? And the reason I ask that is because I'm pretty sure there actually isn't. That is actually, there's a rating system and it's actually kind of a private thing. And so individual movie theaters can prevent children from going to movies or whatever, and most do, but there's no law requiring them to do that actually. And actually the First Amendment applies in that case too, where parents can't allow kids to see movies that are N-17. Like, governments actually can't really restrict that with the law. So, I mean, I guess to answer your question, no, that a similar system to legislate this doesn't work, because it doesn't work with movies either, because we don't have those laws on the books for movies either.
Movie theaters aren't owned by the government. Senator Hicks.
Mr. Chairman, I would suggest that we move on before I find myself drug into a discussion of librarians' jurisprudence training in the Supreme Court cases. So I think that we should just move this discussion along. I don't see where we're making any progress.
Mr. Cook, I do appreciate you being here today. All right, let's go online to Karen Wetzel.
Good morning. Can you hear me?
We can. Please introduce yourself for the record and briefly, and I emphasize briefly, we're running up against the clock. Tell us what you'd like us to hear.
Right. Thank you, sir. Good morning, committee members, Chairman Olson and Co-Chair Washit. I had a whole thing here ready to read to you, but I'd like to make a couple of comments on what people have said today. First of all,
please introduce yourself first.
I'm sorry. My name is Karen Wetzel. Okay. I'm from Lander, Wyoming. The things that I've heard today, I don't understand why any parent would want their children to be able to walk into a library that is unmonitored, because in the libraries that I have walked into recently, they do have the various sections. They have the young adult section, they have the children's section, they have the adult section, they have the nonfiction section, but none of those sections are monitored. As it stands right now, anyone of any age can go in and get onto the Libby system or order a book from home on their computer. And it can be a book like Jack of Hearts and Other Parts. It can be a book like All Boys Aren't Blue. It can be a book like Tricks or Traffic or Smoke or Burned, Fight Club, any of those books that would be considered in most parents' minds, those books would be considered obscene and pornographic. Years ago, libraries used to be a safe place for children to go. Mothers were at home. They didn't work like they are made to work now. Mothers were at home and were able to closely or better monitor what their children were checking out. In today's day and time, children walk into the library and they can pick up and read whatever they want with nobody to stop them because those sections are not monitored. In addition, wow, there actually is a book that I would consider to be grooming in many of our libraries. It's called It Feels Good to Be Yourself. It's a gender affirming book that is geared towards 4-year-olds, and it reads like a Dick and Jane book. Reads something like, hi, my name is Alex. I was born a boy, or Alex was born a boy, but Alex likes dolls and pink dresses. So Alex considers himself to be a girl. This is Alex's gender. That's ridiculous. We don't have to have a 4-year-old reading that. I would consider that to be grooming. The laws are actually the easy part. The challenge comes when a person doesn't follow the law. And if we're looking at who to hold responsible for this material that is placed into our books, the answer to me is simple. In the library setting, we should hold the person or people who purchase the books. I don't know why my screen keeps going blank. Who purchased the books. If that is the board and the director or manager, they're responsible. If that is only the director or manager who does not consult with the board, it would be that director or manager. If it is a foundation or a friend of the library who makes those purchases, it would be that foundation or friend. Whoever purchases the unlawful material, and I'm hoping you will pass HB 194 and make this unlawful, whoever purchases the unlawful material should be responsible. In the past, the question arose, what about the materials purchased prior to the current responsible person or people who were hired or elected that are already on the shelves in our schools or public libraries? This answer is also, to me, a very simple answer. You have the person responsible for the current purchases, remove the materials they become aware of, and if a material challenge comes up, you can have that same person follow the law and remove the remaining materials if those materials meet the criteria. Another thing that comes to mind, there are books available in both the book section and the digital section that anyone of any age can check out. I do not believe that some of these books would pass the Miller test if we're talking about children. And in many cases, I know of many adults who would also not want to even open these books. They are filthy, obscene books. They contain things like rape, sex trafficking, illicit drug use, at times used to heighten a sexual experience, prostitution, incest, or graphic murder. I don't understand why anybody would want to read this sort of book. I know there are people that do, but I don't think they're appropriate for children. Lastly, if you have not had the time, as I realize how busy you are, to read any of the titles that I sent to you previously, I do have transcripts of some of those horrible books in question, and I would be happy to email those to you. I've heard that people that support this type of material or shows that come out in the library, that the library allows people to use, and I quote, "If it helps just one child, then isn't it worth it?" Well, what about if it harms just one child? Is it still worth it? It is harming children, more than one child, and there is no good reason to continue to have this overly graphic, obscene, or sexual material available to minors. They are minors for a reason. They're not adults. They should remain minors until they reach the age that they can vote or drink or go to a strip club. They can't do this as children, and they shouldn't be allowed. And that's where we need to change our laws to maybe children don't have the same rights as adults have in many cases, and they shouldn't have the same rights when they walk into a library. Thank you for allowing me to speak, and I stand for questions.
Thank you, Ms. Wetzel. Any questions? Seeing none. Thank you again, Ms. Wetzel. Please bring in Patricia McCoy.
Can you hear me?
I can. Please introduce yourself to the committee and where you're from, and tell us what you want us to hear. You're really up against the clock, so please be brief.
Absolutely, Chairman. My name is Patricia McCoy. I thank you for allowing me to speak today. I am that mother that Ann Lucas mentioned to you at the beginning of this discussion. I went to the Laramie County School Board with my daughter because I had fought against the school for multiple years to keep these books out of the hands of my daughter. I followed the opt-out process. I followed the complaint processes. I had meeting after meeting after meeting. Then I show up to the school board with Me, Earl, and the Dying Girl, as well as Genderqueer. I did not even make it to opening Genderqueer because the first sentence that I read from Me, Earl, and the Dying Girl got me stopped immediately because the chairman of the board advised that they would get kicked off of YouTube for its inappropriateness, and that I was no longer allowed to read from that book or any more books during my testimony. If I cannot read that book to a room full of adults, why was it put in the hands of my child when she was 14 years old? And why was I, as a parent, pushed aside and refused to be listened to, being told that I wasn't being understanding and I wasn't listening to my daughter? My daughter never questioned anything until they began putting books in her hands and putting pieces for her to perform in speech and debate before her. Even after we repeatedly put our parental rights forward and said, this should not be happening. This goes against our beliefs. We do not want her to have access to it. Please refer to our opt-out forms. They still violate those forms to this day with my youngest son. He's going to be a senior next year, and I'm still fighting against the school for these things. But I will say that after parents fought for the new opt-in policy in our district, things did change for the better. Not completely, but we are getting there. With my youngest son, the librarian knows that she is supposed to call me if any of those books are part of certain genres that I put in our opt-in policy options. She found a book that he handed to her that his friend recommended. My son did not look at the book. He didn't read the back of the book. His friend recommended it, so he grabbed it off the shelf and handed it to her. She advised him, because of the type of book it was, she would have to call me. She did not call me for this book because she found that this book was extremely inappropriate, not just sexually explicit, but also in other areas. And she refused to put it in my son's hand, knowing that I was not going to allow it to be in his hand either. So I applaud her for that and her hard work. I will tell you that as of Saturday, the last time that I checked, there are 49 books that were nominated as being sexually explicit. And of those 49 books, 48 of them were deemed to be sexually explicit. And all 48 are still in all of our junior high and high schools in Laramie County 1. Parents must opt in for their children to have access to that. The fact that 48 out of 49 on the list were deemed sexually explicit, but you still have people telling you today that there is not an issue with these books. They don't meet the Miller test that's for adult books, not children's books, so they couldn't possibly be inappropriate for children. I applaud the co-chair for bringing up genderqueer and asking people to read it, because I have read the entire book. I have read several of these books. I have nominated them myself to be put on that list because they are sexually explicit. They are beyond inappropriate and should not be in the hands of 12, 14, 16, even 17-year-olds. Until they are 18 and they can do what they want legally and the parents no longer have a say, it should be up to the parents what their child has access to, and they should not be available funded by taxpayer funding, which public schools are funded through taxpayer funding for part of their funding. I just listened to that in the budget discussion in the board meeting last night. These things are funded by our money, and they should not be in our public school libraries. If you want them in the public library, that's a different story. But when they're supposed to be in an educational library where our students have access to them to be learning things, you can tell stories of two mommies, two daddies, two teenagers that are confused about themselves and who they are. You can tell those stories without being sexually explicit, and they do not belong in our libraries. And again, I thank you for your time.
Thank you. We appreciate your testimony this morning. Representative Filer.
Thank you, Mr. Chairman. Ms. McCoy, you and I have had many conversations about this same topic, and I'm glad that you brought up all the different safeguards and stuff that our school district has and all that. And within our discussions, our past discussions, you are very adamant on parental control. So if we can expand more on parental control and not necessarily tell other people what they can and cannot read, would you be more in favor of that approach than just saying that, no, we can't do this and actually have constitutionality issues? Because that's my biggest worry on this is the constitutional part of it.
Ms. McCoy.
Thank you, Mr. Chairman, and thank you, Representative Filer. I appreciate the question. As previously stated in our other discussions, I do support parental decisions being the key factor here. However, when those are not being followed, I got lucky with this librarian. I didn't get lucky before. What is the parent's recourse when it's not being followed? Who do we go to say these books are being put in the hands of my child after I asked them not to be? What is our course of action for getting this corrected and preventing it from happening in the future?
Thank you, Ms. McCoy. Further questions? Bring in Rachel Martinez, please.
Hello. Can you hear me?
Good morning or afternoon.
Good morning.
Okay, please tell us your name, where you're from, and we're up against the clock, so please briefly tell us what you want us to hear.
Sure. Thank you, Mr. Chairman and members of the committee. My name is Rachel Martinez, testifying as a concerned citizen from Cheyenne, a parent and grandparent who values libraries and freedom of expression and who values parental choice. My mom was a librarian in the Laramie County School District 1 system, and I sat on the Laramie County Library System Board for 6 years. And I currently spend hours every week at my current library, the Laramie County Library, with my grandsons, specifically on the children's second floor, where we read, attend programming, use the youth computers, which have so many safeguards for access, and we explore for hours upon hours. There are clear protections for our youth. I have seen multiple interactions with the librarians, they know us by name, who do monitor the area. Just a few weeks ago, they asked me if I was there with a minor because they were concerned that I was just on my laptop. My first concern is that this legislation falls under the statutes of crimes and offenses. The library should be a safe space, a community hub for expression of ideas, not a place where we are facing extra criminalization and extra steps to opt in for reading or partaking in events. Our library system works. Yes, can processes be improved? Of course. Can the Libby system be better? Great. But does additional government oversight need to exist to do that? Absolutely not, and especially not extra criminalization to make the jobs of our librarians even harder. My next concern is that this sure carries a lot of weight for bad actors to insert themselves into our beloved library spaces. This opens the floodgates. We've already heard about large groups of individuals, national organizations with unlimited resources to call the shots, put in multiple challenges to whatever they deem obscene materials or obscene events. Representative Lucas admitted she's bringing this in from other states. Some of the books challenged, and I think Mr. Mullen mentioned this, but they're beloved books by Roald Dahl and J.K. Rowling. And by the way, someone could say that C.J. Box has violence and obscenity in his books. Among the thousands of books on the shelves, I walk by those shelves, we check out multiple books with my grandsons. Who gets to decide? We talk about like, well, I know it when I see it. Well, you know it when you see it. So who's correct? I just have huge concerns of the gray areas in this legislation, even with the stated exemptions. Our books have hard things in them. This is life. My own kids were never restricted in books they checked out. They all graduated top of their class. My son was the top graduate of the University of Wyoming. We talked about hard things as a family, and yes, I would absolutely allow them to read queer, and Earl and the Dying Girl. No restrictions. That is my right as a parent. Those that are concerned about public access, maybe curate your own libraries, because libraries are supposed to be the great equalizer in our communities. I served for years with Lucy Osborne, a longtime librarian here in Laramie County, and she was a big advocate of that public access to our libraries without that additional restrictions that we want to see put in place. So my concern here is where's the line? If I allow my grandson to read a book about architecture and the Venus de Milo or Statue of David is in that book, even at the youth level, I now have to worry about that, or a librarian that shelves that book has to worry about the additional steps to access the material and where it should be and what sexual feelings this might evoke. I mean, parental rights and decisions are already limited with parental choice at the school level, and now you're introducing more restrictions at the public library. I just don't know when this is going to stop. So I would just like to see that parents, in my case, grandparents like me, who are afforded the opportunity to check out these books, keep their rights to oversee the books their kids are reading, attend a diversity of events that are allowed, because we know this will also spill over into events and programming of the library, and who doesn't want to attend because they're afraid it's too explicit for their kids. Let librarians and libraries do their jobs and use the processes already in place. Let's improve those and protect our youth. Thank you.
Thank you for joining us. Any questions for Ms. Martinez? Don't see any. Appreciate you coming today and testifying.
Thank you.
Bring in Representative Bear.
Hello, Mr. Chairman. Can you hear me?
We can, Representative. We're up against the clock, so please be
I
brief.
understand that, sir. Thank you, and I'll be very brief. Thank you, Mr. Chairman, Joint Chairman, and the Joint Judiciary Committee for allowing me to testify today before you. Also, thank you for taking the state's responsibility to protect children very seriously in these first three subjects this morning. Fentanyl, clearly an issue. Take a brief moment and read a letter from a psychiatrist that really tells us the why this is important for the state to get involved. This is a board-certified psychiatrist and one of my constituents. Dealing with this issue in our community, he wrote this letter. I have been made aware of a growing public concern over the availability of sexually explicit reading materials in the children and teen section of local library. As concerns the present debate about whether these materials should be made available to children and adolescents, I have been asked to provide my professional opinion on the matter. Specifically, I've been asked to ensure or to about the exposure of sexually explicit material as on the potential to cause psychological harm to this apparent target audience of minors. In a word, yes, and greatly so. With abundant scientific literature accumulated over the years concerning the problem of pornographic addiction in adults, why would we not consider the harm of sexually explicit material exposure to the developing brain? One must also question the motives of those adults who make these attempts to prematurely sexualize children There appears to be no decent rationale for this, and simple depravity seems an inadequate explanation for the systematic nature of these attempts to normalize the sexualization of minors. A reasonable person would rightly question whether these initiatives and the resistance of the governing bodies to correct the problem represents a more sinister form of social engineering. Based upon my review of some of the reading materials in question, I believe that the introduction of sexually explicit media into the children and adolescent sections of the library should be of all a call to arms for the parents and reasonable adults in any community. Protecting our children is a duty. It is apparent that we cannot rely upon federal and state government to provide that protection. That duty, as it should be, falls primarily on the citizens. End quote. And I thank you very much for listening to that. But I also want to share with the committee an idea. As I listen to the committee, you're clearly concerned about protecting children, but at the same time, there's concern about taking away the freedom of librarians to do their job without fear. And so I would like to remind the committee of a bill that we just recently passed in both the House and the Senate. And it was vetoed by our governor, but that was the SAPA bill amendments of 2025. And the particular methodology used in that bill was to fine the department for an infraction. And I think this would probably solve both things. And I'd also suggest, rather than taking a shotgun approach at obscenity, which is clearly, based on the testimony you've heard today, difficult to prove with the Miller test and the caveat of community standards, which is very difficult to really nail down what that is, that rather the committee take a more narrow rifle shot at this subject and define exactly what sexually explicit is and make it so that sexually explicit materials in children's sections of libraries is what you're going after. Obviously, the Libby situation is another thing you could address with age verification or some other parental controls. But I would recommend at a minimum that you take an approach that allows there to be some teeth in the bill, but also really gets after the crux of the issue, and that is sexualizing children. So with that, I thank you, and I'll stand for questions.
Thank you, Representative. Any questions for Representative Barron? Seeing none. Thank you so much.
Thank you.
With that, I'm going to close public testimony. Okay. Committee, what's your pleasure? Representative Webb.
Thank you, Mr. Chairman. I believe we have a responsibility to protect children. We've seen today that minors can be victimized by people that we would not suspect. I think we need to look into things of like the exemptions. We need to look into what desensitizing these children or these things have on children, the desensitizing effect. We need to define sexually explicit. And I kind of compare this to going into a Maverick. Maverick has a portion that minors can't go into. Makes sense, makes common sense. I think we need to find a common sense solution for this.
Representative Lean.
Thank you, Mr. Chairman. I'd like to move a request for LSO to draft a bill regarding public and school libraries to ensure that sexually explicit materials are not placed in children's sections of any library containing the following features: a definition for sexually explicit, 2, a monetary penalty for institution that violates the requirement, such as found in the SAPA bill, Senate File 196 from 2025, and private right of action for the ability of an interested party to bring a civil action to enforce this requirement, a sovereign immunity exemption. And then I did email this to the committee and to Mr. Fuller. The sexual definition I'd like to follow would be around Iowa's act, and we could tweak it to whatever we want it to be. The sex acts would be, or sexual activity is defined as penetration of the penis into the vagina or anus, contact between the mouth and genitalia or mouth and anus, or by contact between the genitalia and one person and the genitalia and the anus of another person, contact between the finger and hand of, sorry if I get flushed. So contact between the finger and hand or other body part of one person and the genitalia or anus of another person, except in the course of examination or treatment of a person licensed pursuant to, and then they have their codes listed. We also have codes for vulgarity, obscenity, and sexual assault. We could follow those. Ejaculation of another person onto another. The use of artificial sexual organs or substitutes thereof in contact with the genitalia or anus, or the touching of another person's own genitals, the anus with the finger, the hand, artificial sexual organs, and other similar device in the direction of another person.
Is there a second to the motion? Second by Representative Brady. Discussion on the motion? Seeing none? Oh. Senator Cole.
Yeah, thank you, Mr. Chairman. There's definitely a need to address this. I think when we start to quantify what was just listed is probably the problem. I'm willing to discuss it, but I will tell you, I will not, criminalize librarians. Maybe the directors, but not the librarians. We need to get a handle on this, and this ALA and all the things the Wyoming Library Association does, which I've read, well, I had the chance to read it, is frankly appalling. I think there has to be something to move forward. I don't know if this is the right thing. It may be too broad, it may go too far, and one person's obscenity is another person's, something they're fine with. And I think that's the slippery slope we risk when we go down this road. And but it's definitely high time that we address it. These influences are coming outside of Wyoming, not from inside of Wyoming, but they've adopted these said practices. And I think we have to get our arms around it. So that's my 2 cents on being very cautious on painting this picture we're currently trying to paint. But we need to take action. And I think through this educational process, we can get there. Thank you, Mr. Chairman.
Further discussion on the Senator Craigo, and we'll come back to the sponsor.
Thank you, Mr. Chairman. Just so the general public's aware and everybody that's watching, I mean, the SEPA bill has a $50,000 penalty. I believe is what it is. And so one book would be, in theory, based on the proposed draft, would be a $50,000 fine. And I don't know how the draft, I guess we can work on this as it goes. The committee can, but is that after you've requested the book to be removed from the adult section? Is it before that? So if a parent happens to find one book that the librarians didn't know about, is that a $50,000 fine? I mean, I have no problem with the idea of requiring that the books be placed in the adult section. I have no problem with that. The penalty parts are where we're going to get stuck in the weeds and where we're going to lose momentum on the idea and getting it passed through both houses, both chambers of the legislature, right? So if we want to actually do something, accomplish something in this, then I think we need to think about that as we move forward. This committee needs to give that a lot of thought, because just because we have an idea that we think we can get it through, we better make sure we can. And I just don't want us to do all this work and then get a bill to the floor that's going to die strictly because of how extensive the penalty provisions are. Whereas if we just if we have the idea that we don't want these books in the children's section, which I think all of us agree on that, then let's focus on that and not as much, because the proposed draft focuses way more on the other stuff. So that's just my 2 cents. I'm happy to move this down the road, but I think we need to worry about that. Thank you, Mr. Chairman.
Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. I agree with Senator Craigo. The penalty gives me pause, but at this stage, all we're asking for is a bill draft. I think we need to have something in front of us that we can look at and that we can work. I think the need for this bill is very obvious. These books are rampant across Wyoming. This idea of local control, I support, but local control is obviously not working if these books are in our libraries. I'm sorry, but I don't think there's a single person on this dais up here who would look at this book, Genderqueer, the images in it, and not say that it is pornography and that it is explicit and that it is sexual and that it doesn't, not only, I don't think not only does that book not belong in a children's section, I question whether it belongs in a publicly funded library in the state of Wyoming, period. But if we can at the very least protect our children from the sexually explicit material, I think it's worthwhile taking the time to go through a bill draft and make sure we get it right. So I'll support the bill draft. I think we really need to look at the penalty and who we criminalize and how we criminalize things, but I'm in favor of moving the idea forward.
Mr. Chairman.
Senator Crum.
Yes, Mr. Chairman, couple things. Like the two previous speakers, I want to make sure this bill gets through because there's no place for this type of material in the thing. So we need to be really careful how we draft it, that it gets through and that it is constitutional. We get through because there is no place for this. The other thing I'd like to look at is there a way to include, we've had a lot of discussion about parental consent, that there's actually an opt-in versus the opt-out piece, that we would include some sort of parental consent for kids checking books out of libraries.
Thank you, Mr. Chairman. Thank you. Senator Cole.
Yeah. Thank you, Mr. Chairman. I think to dovetail onto that thought about the parental consent, I think we have to have that parental consent to view this material within the library. It's been testified to that you can go in there, look at this material, but not check it out. And of course, nobody has any control over this. It's just, I guess, free ranging people. And I think that has to be dovetailed into this, that if we're going to have a section for adults, because we're really talking about adults here, that's the issue, or excuse me, minors. And the minors are the ones we're trying to, that's what I'm talking about. And we need to make sure that the minors do not view this material. And it goes against the Wyoming Library Association material right on their website, I might add, on free access for all. And I find that appalling. We have to have a differentiation between minors and adults. And if it takes a separate section and then the parents opting in to letting their child view that, that's the parental choice. But I think we have to restrict the ability to have those books circulated within the library without checking them out. We have to be very careful that we make sure we bring that into this conversation. Thank you, Mr. Chairman.
Further discussion on this? Representative Singh.
Thank you, Mr. Chairman. Just one little caveat, and it may not be in this particular motion, but we do need to address access online to the online database as well. And so that may need to be a different motion, but I wanted to bring attention to that.
It could be a separate bill draft, or it could be an amendment to brought next meeting. Back to the bringer of the motion.
Thank you, Mr. Chairman. I just ask that we take a good hard look at this, and I'm willing to work with the entire committee on enforcement and take into consideration everybody's opportunity to amend that the way it needs to be done so that it can get through so we can protect our children.
All right. All those in favor of the motion, everybody clear on what we're voting on? Okay. All those in favor say aye.
Aye.
Those opposed, no. The bill draft has been requested. Are you clear, Mr. Fuller, what we're after here?
Yeah, Mr. Chairman, I've got enough to get started. Thank you.
All right. Representative Singh.
Thank you, Mr. Chairman. I'd like to make a motion to draft that bill on the online access to materials that should be prohibited to folks that are under the age of 18, similar to our legislation around public access to obscene materials.
Representative Lean.
Mr. Chairman, I would ask LSO, I'll second the motion for discussion. I would ask LSO that in House Bill 43 on page 3, line 16 to 22, it specifically includes provides access to the internet systems operated or services offered by libraries or educational institutions. That bill is the age verification. Does that legislation that was passed and signed this year supersede the exemption for librarians and libraries?
Mr. Fuller, are you following?
So Mr. Chairman, Representative Lean, House Bill 43. And you're looking on page. Yeah, Mr. Chairman, happy to opine, either after lunch or at another meeting. I'd like more time to read and review this.
Don't you have AI over there that you can just plug this into?
He's got Perry.
So, with that in mind, if it's satisfactory to the committee, maybe we'll come back after lunch and pick up right here with this motion, and answer any questions we might have about this motion before we vote on it. Just kind of suspend our actions to give Mr. Fuller a little bit of time to digest what we're after, and perhaps the bringer of the motion and maker of the second will consult with Mr. Fuller over the lunch period to make sure we get this amendment the way we want it to, or this motion to be what we want.
Thank you, Mr. Chairman.
With that, members, we're going to break for lunch, and we will only take a short lunch. We'll be back at 1:30. 1:30. So we got work to do this afternoon, so go to a fast food place or whatever, and we'll be back at 1:30.